All right. So welcome everybody. I hope everybody is doing well this morning. As I just mentioned, today is August 1st, 2024. It's important that I tell the date of this class. This class is the NAR settlement and what it means for agents in Georgia. The reason I say it's important for the date is the settlement agreement is a preliminary settlement agreement and is still subject to change until we get final court approval, as well as approval from the Department of Justice. So everything I'm going to cover today is as it is as of at least last night at 2 a.m. when I finished this class. Things change very rapidly. It is also back to school for the majority of our school districts here in Georgia, and this is almost back to school for us as the terms of the preliminary NAR settlement do go into effect August 17th. So we are going to dive in. As I mentioned, if you have if you've already done so, you do not need to type in your name in the chat. But if you have not yet done so in the chat, please type in your name, Georgia real estate license number, email address, and phone number. I do have a link to a handout. It is a big package. You don't need it. I just wanted you to have it. We are going to cover everything in the class today. You are more than welcome. This is the first time teaching it, so I know everyone will get CE credit. However, our school, the Real Estate Academy of America, this class is just approved for CE credit for a Georgia license. So if you hold a real estate license outside of Georgia, I welcome you to stay, but I don't know how those CE credits, if you'll actually get the continuing education credits. Welcome back to the people that have taken our classes before. If this is your first time taking a class with me, let me introduce myself. My name is Dana Sparks. I am the qualifying broker of Maximum One Greater Atlanta Realtors, and I am the director of the Real Estate Academy of America. Today's class is, I tell you that because I wear a hat as a broker as well. And so the terms of the NAR settlement affect my firm and my agents and me as a broker. But in today's capacity, I am teaching it as an instructor for students, and we have attendees from every brokerage. So I will not answer any, I see some agents that are in my firm. I'm not going to answer any specific questions related to our brokerage or any other brokerage. I am going to present information in general as it stands with the terms of the NAR settlement as it has been approved, the preliminary approval as of today. And I do refer you to your own broker. At the end of the presentation, you'll see I do have a list of several resources for you, as well as other places you can go for additional information. Today's class, I am going to cover a little bit about the settlement, well, a lot about the settlement, as well as it just coincides great. I feel like we're back to school as well. And this does coincide with the Georgia Association of REALTORS release of the revision of their contracts that came out July 1st. So you'll see I'm going to talk about how the terms of the settlement, what they are, how they impact you as an agent in Georgia, and what to do specifically with respect to the GAR contract forms. My personal goal as an instructor is that the 3 hours will go by very quickly for you. The CE credit will be a bonus for you, and you will walk away from this class with information, hopefully not to confuse you even more, but concrete information that you can now take as an agent and utilize in your day-to-day practice when meeting with buyers and sellers and interacting with your colleagues and your co-op agents. And I strive and pray that I teach and present the information in a way that is accessible to you and makes sense to you, clicking so that you don't have to memorize something, but it will make intuitive sense. So with all that getting started, we have a lot of people in this class and there's a lot of information to cover. I will let you know towards the end of the class, I have specific scenarios with examples and how to fill out the forms. So there are going to be a lot of questions. Some I will answer as you ask them. Others I will wait because I know I might cover it in a little bit. So with that being said, let's dive in. So I'm going to share my screen. And I do have, if you see me looking to the side, I want to be able to see what you guys see so I can see it. All right. The NAR settlement and what it means for agents in Georgia. This is a Georgia Real Estate Commission approved course number 77540. I am the instructor. That is my contact information. This course is sponsored by Maximum One Realty Companies, and that is the website for more information there. Again, today is August 1st, 2024, and as of today, there is no final court approval and no final Department of Justice approval. So today's presentation covers what has been preliminarily approved by the courts and is effective as of August 17th. The CE is offered through the Real Estate Academy of America, which is Georgia Real Estate Commission School number 6915. This has been approved for CE credit. The school has to renew the end of December 2026. It is a virtual remote broadcast of an approved in-class course, 3 hours of CE credit, no homework, no exam, no prerequisites. In general, you can only take one virtual CE class at a time or with overlapping times, regardless of the school offering the course, in order to get CE credits for either course. The way we do attendance at this school is via the chat function. So I will ask you 3 times in the chat to enter in your name, real estate license number, and email address. At the beginning of class, if you've already done it, don't do it again. When we come back from break and before you leave the class. Additionally, I will ask some questions and I will ask for your answers and for you to type them in the chat. In the interest of time, even if I have gone on in the presentation with the answer, please go ahead and type your answer in the chat. That way we can demonstrate that you actually were here watching or interacting and paying attention to the class and you didn't just turn on your computer and walk away. Again, for GREC, you can get CE credit for any specific course number once every 12 months. It's not per topic, it's per course number. So you can take 30 more hours of CE credit on this same topic. You will only get credit you will get credit for each of those if it is a different course number. And there is a prohibition against recruiting. If so, contact me, GREC, or Heidi Kelly, who is the coordinator of our school. There is the website for our school and our online calendar. Handouts, if available right now, I am sending them in the chat. And they will be posted. I do not have them posted on the website today, but they will be posted on the Academy's website, realestateacademyofamerica.com. You'll see a tab that says course handouts and videos. Scroll down that page for handouts for this class or any other class where we post the handouts. All right, today what we are going to cover is just a brief background on antitrust lawsuits against NAR and multiple brokerages. Why on earth is the Department of Justice even involved in all of this? I'm going to talk just a little bit about the NAR preliminary settlement, and it begins with the Seitzer Burnett case, which was the case in Missouri. What does all this mean? What is NAR's goal? Are brokers still allowed to offer co-op compensation? Additionally, I am going to get into, that's going to be the introduction. I am going to get into the nuts and bolts of the preliminary settlement and break it. There's a lot. I have in the handout, I have a copy of the actual settlement itself from the court. It's a lot there. I have broken it down for today's class into 4 key elements that impact you as an agent practicing real estate in Georgia. Those 4 key elements are: you are required to have a signed buyer agreement prior to showing. You must get client or customer approved compensation of brokers and agents. You must, or the settlement requires separation from any information regarding a co-op commission or co-op compensation information from any and all NAR member, MLS Services, or any MLS Services that have chosen to opt in to be covered by the settlement. And the 4th key element is release of liability for NAR members. I'm going to talk about all of those in depth. What about agents and brokers who are not members of NAR? Here in Georgia, we have many agents and brokers who do not belong to NAR. What does all of this mean for them? I'm going to share with you what Georgia MLS and what FMLS have stated about the settlement agreement and their policies regarding that. Let me mute everybody. And then we're going to cover putting all this into practice in Georgia. You will see, you'll be so excited. We are so fortunate and so blessed that Georgia is years ahead of many other states. And we're going to talk about how are real estate professionals paid, the GAR, Georgia Association of REALTORS compensation forms and consumer brochures, and then the nuts and bolts, or the information of how do you apply all of this in practice. We're going to address addressing compensation in a real estate transaction. What form do you use? Key questions for showing any and every property. 6 different scenarios. Best practices for sellers and buyers agents. Myth busting. Opportunity for real estate agents in Georgia. And then finally, resources for you guys to have as you move forward. Brief background. You guys, these first few slides, I'm just going to read through just to give you, there is a lot of information out there. This has been going on for quite a long time. I just want to give a very brief background to some people. It's very confusing, and there is a lot of information out there, a lot that applies to Georgia, a lot that does not apply to Georgia. And it just can be very confusing. So why are we even here? What has brought about this NAR settlement agreement? Well, it all started with several class action lawsuits where the plaintiffs are the ones that have brought the lawsuit. They have charged the National Association of REALTORS and various brokers, basically the majority of brokers, real estate brokers throughout the country, of violating antitrust laws. What does that mean? Well, another way of thinking about violating antitrust laws is price fixing, specifically commission fixing, and how those relate to the MLS services. Antitrust laws are the broad group of state and federal laws that are designed to make sure businesses are competing fairly. The trust in antitrust refers to a group of businesses that team up or form a monopoly to dictate, I'm missing something. Basically, to dictate prices and fees charged for services or products rendered. Why on earth is the Department of Justice even involved in all of this? Well, the Department of Justice, or the DOJ, you hear the DOJ all the time. That's what it stands for, is the Department of Justice. So the Department of Justice, they have an entire antitrust division, and that division enforces federal antitrust laws to promote competition in the U.S. economy. The division's mission is to protect consumers, workers, and taxpayers by preventing anti-competitive conduct and ensuring businesses can compete on price, quality, innovation, wages, and pricing in a particular market. Okay, now let's talk about another term, class action lawsuit. A class action lawsuit is a civil lawsuit brought on behalf of a group of people or business entities who suffered common injuries as a result of the defendant's conduct. In these cases, the defendants are the National Association of REALTORS and all the brokers specifically named in these individual lawsuits. They're the defendants, and the plaintiffs are the individuals. The majority of them are sellers. There's other lawsuits going on, but who have brought this lawsuit against NAR and the brokers, charging the complaint was that they are price fixing and it is a violation of the antitrust laws. So result of the defendant's conduct with at least one individual or entity acting as a representative of that group. Class action lawsuit plaintiffs usually don't pay attorneys out of pocket because lawyers are typically paid on a contingency basis in these types of lawsuits, and only receive compensation if they win the case. This means that if the lawsuit is unsuccessful, the plaintiffs aren't required to pay attorney's fees. There are lead plaintiffs in a class action lawsuit. Those are the names that you're hearing when these issues are being addressed in the media. Seitzer Burnett, for example, in Missouri, the Missouri case. Regarding NAR and the brokerages specifically, there are multiple class action lawsuits throughout the country against NAR related to broker commissions, including these three are the biggest: Moral, I don't know how to pronounce it, and others against NAR and other brokers. That was filed on behalf of that person against NAR and four of the largest broker franchisors. UMPA, same thing, versus NAR and the other brokerages, filed by that person in Ohio and Maryland. And Seitzer Burnett, which is the biggest one that we are hearing about, filed in a Missouri federal court by a group of home sellers against NAR and other defendants, including Anywhere, Berkshire Hathaway, Home Services, Keller Williams, and Remax, and others. So fast forward to today, the NAR has received preliminary approval of the settlement agreement, and it all begins with the Seitzer Burnett class action lawsuit. So Seitzer Burnett is a class action lawsuit that was filed in Missouri in a federal court by a group of home sellers in the state against NAR and broker defendants. The plaintiffs claimed that real estate commission rates are too high, buyers' representatives are paid too much, and NAR's Code of Ethics and MLS Handbook, along with the corporate defendants or the brokers' practices, lead to inflated commission rates. At the October 2023 trial, the plaintiffs took particular issue with cooperative compensation. That's co-op compensation that you are familiar with, where a buyer's broker gets compensated from the seller's broker sharing the commission they receive from the seller. So that is that's what it means by co-op or co-op commission or co-op compensation. So in other words, when a listing broker makes an offer of compensation to the cooperating broker, so the listing seller agrees to pay the listing broker a certain amount of money, and the listing broker says, I'm going to share part of that money I'm getting from the seller. I'm going to co-op with a broker representing a buyer and that's what that means. Offer of compensation does not mean that a specific amount must be paid. The offer can be any amount, including in many cases $0. NAR in the case introduced evidence to show how the real estate marketplace works and how cooperative compensation benefits consumers. NAR also showed that its rules prohibit anti-competitive behavior and encourage the free market and competition. However, the jury found in favor of the plaintiffs and ruled against NAR and the brokers named. The NAR and the brokers filed motions to appeal the decision. In the interim, remember, this is the case in Missouri. In the interim, there are many quote unquote copycat class action lawsuits filed throughout the entire country, including Georgia. As of today, the Georgia lawsuit has not been decided. For the Seitzer-Burnett case, many settlement agreements were proposed. So there are specific brokers, Keller Williams, Remax, Anywhere includes broker brands such as Coldwell Banker, Century 21, ERA, Better Homes and Gardens. They have finalized their own independent settlement agreements with the plaintiffs. Home Services of America, which includes Berkshire Hathaway and Harry Norman, is still negotiating their settlement agreement with the plaintiffs. That may have been decided by now. I'm not 100% sure on that. NAR also has negotiated a settlement agreement, and the NAR agreement only has preliminary approval by the courts as of this class. That's the agreement. That's the settlement agreement we're going to address today. The agreement still requires final court approval and approval by the Department of Justice due to the DOJ is involved because it's violation of antitrust laws because of that's the nature of the lawsuit. The plaintiffs have requested a hearing for final approval on November 26th. So when it gets close to that time, we will see if we get final approval or if there are motions filed and it gets continued on. Okay, Dana, what on earth does all of that mean? What that means, if you are an agent with a brokerage who has a finalized settlement, those other ones I've named, you must check with your broker regarding the terms of your firm's settlement agreement. The terms of some of those individual settlement agreements might be the same, might overlap, and might be different or might have more terms in them than the NAR settlement agreement. So you need to check with your broker or your international corporate representative, regional representative regarding the terms of your own terms of that settlement agreement. If, however, you are a member of NAR, i.e. you're a realtor, you belong to a local board of realtors, therefore you belong to the Georgia Association of Realtors and to the National Association of Realtors. If you're a member of NAR, regardless of the brokerage you hold your license, as an agent, the terms of the NAR settlement also apply to you. But for all members of NAR, again, we don't have final approval. Some of the terms might be tweaked, might change, so forth and so on. The terms of the preliminary settlement do go into effect August 17th. NAR's goal is they agreed to settle in order to protect its members, 1.5 million active NAR members throughout the country, and to reduce the members' liability as well as their own liability from additional lawsuits. The settlement applies to NAR members, state and local realtor associations, realtor MLSs, and brokerages with an NAR member as a principal. That means the qualifying broker belongs to NAR. With those brokerages having residential transaction volume of over under $2 billion or less in volume in 2022. The terms of this settlement also cover any non-realtor entity who chose to opt in to be covered by this settlement agreement. The deadline for them to opt in was back in June. If approved, if we get final approval, if the courts approve this agreement, the settlement will also require NAR to pay out $418 million in damages. That award money goes to all of the attorneys involved and to the seller plaintiffs. So as the class increases, each plaintiff will their proportion of the money they get changes based on the total number of members of the class. One more thing, I don't think I have it on this slide, so let me back up. One more thing I don't have on this slide. Why did NAR settle? And the other brokerages, why did they settle? Well, as I mentioned, there are a number of these lawsuits throughout the majority of states in the country. That means without a settlement agreement, that means NAR and all of those brokerages have to defend themselves in each and every lawsuit throughout the country. With a settlement agreement, in one of the cases, for example, NAR settlement agreement in the Sides Burnett case in Missouri, that then, once the settlement agreement is approved, that then removes them as a defendant from the other lawsuits throughout the country. Same with the other settlement agreements, Keller Williams, Remax, Anywhere. Because they have a settlement agreement in one of the lawsuits, they are now removed. I'm sure there's a different legal term, but in essence, they are removed from being a defendant in the other lawsuits. That means they don't have to pay their attorneys to go to every other lawsuit in every other state and defend themselves. So that's another reason why all of these companies have chosen to work on settling out of court, or settling rather than continuing to fight each and every lawsuit. All right. Are brokers, this is the biggest question. Are brokers still allowed to offer co-op compensation? The answer is absolutely yes. As of today, August 1st, 2024, yes. NAR is one of the oldest and largest trade organizations, and they stand by the benefit of cooperative compensation. It makes efficient, transparent, and accessible marketplaces possible, which serves consumers and advances home ownership. All right, that is the background. Let's now move on to the I have tried to boil everything down to 4 key elements that will impact you as an agent here in Georgia. So again, as I mentioned, one of the key things is agents must have a signed buyer agreement prior to showing any property. The second big issue or big deal that impacts you as an agent is you must get client or customer, the consumer with whom you are working, regardless if their relationship with your broker is that of client or their relationship with your broker is that of customer. That consumer must approve of compensation to the brokers and agents. Number 3, there is a separation of co-op compensation information from, I have MLS. That should really be an NAR member MLS, and I'll cover that a little bit more specifically as we move on. And another key thing that impacts you as an agent in Georgia is release of liability for NAR members, NAR associations, and NAR MLS services, or any non-NAR member who chose to opt in to be covered by the settlement. So let's talk about each one of these in depth. Signed buyer agreements prior to showing. The terms of the settlement state that you must have a written agreement. Let me back up even a little more. Throughout the presentation and throughout our forms, I'm going to say broker. A lot of the majority of these slides say broker. That means by extension, you as an affiliated licensee. You are an affiliated licensee. Affiliated with whom? Affiliated with the broker, the brokerage with whom you sign an independent contractor agreement. And those terms, there are certain situations when they are separate, when agent means agent and broker means broker. But if it does not specify a difference, then broker and affiliated licensee or the term agent are used interchangeably. Well, Dana, why does all your stuff say broker? Well, because you are affiliated with your broker. All transactions are done in the name of your broker. All contracts are signed in the name of your broker, and all compensation is earned in the name of the broker. So you, however, are the agent of the broker or affiliated with the broker, and you as the agent, you are the one that's out there actually interacting with the consumer, with the public, signing these forms, signing these documents, explaining the process. But just know, as we move forward, don't zone out just because you see broker and say, well, I'm not the broker of the company. In these slides and in the terminology, in the GAR contracts, when it says broker, it also applies to you, the agent, the affiliated licensee affiliated with the brokerage with whom you have signed an independent contractor agreement. So don't zone out just because you see broker. All right. You must have a written agreement with a buyer disclosing compensation prior to showing property. Total compensation that the buyer's broker is allowed to receive from the seller's side. So you have to have them sign something. In that document, you have to disclose what they're paying, and you have to disclose the total amount of money that broker, the buyer's broker, is allowed to receive from the seller's side, and that must be approved by the buyer. Compensation must be specific and calculable, hard to say, not open-ended. I'll give you examples of that when we get to that section. You are prohibited from stating or writing or putting in a contract or a buyer brokerage agreement, customer agreement. You are prohibited from stating that your services to a buyer are free or no cost or $0. Brokerage agreements must contain language that commissions or compensations are not set by state law and are negotiable. The second key element, client and customer or your consumer, your public person, must approve of compensation to brokers and agents. Again, you agents working with buyers, filling out buyer forms. You can never, and even in your presentations and any of materials you have or what you say, you can never say your services are free to a buyer or cost $0. We're going to address some of this stuff later. Also for buyers, as I mentioned, total compensation that the buyer's broker may receive, the maximum amount allowed, must be approved by the buyer. And again, buyer's agents, the buyer's broker compensation must be specific and calculable, not open-ended. In other words, you can't say whatever the seller side is willing to pay me is what I'll take. Can't do that. Sellers, you listing agents, the seller must approve of the amount that the seller's broker may share with a buyer's broker. And brokerage agreements must contain language that commissions or compensations are not set by state law and are negotiable. Let's talk a little bit about the MLS services. Again, the third key element from one of the terms of the NAR Settlement Agreement has to do with the MLS services, the NAR member MLS services. So first of all, let me just start by saying, as I've already said, the NAR Settlement Agreement does not prohibit co-op compensation. Co-op compensation between brokers is allowed. A realtor-owned NAR member MLS, however, may have no information about the co-op compensation, and you can't attach a compensation document. Additionally, you agents using showing time, you cannot put any co-op compensation information in showing time. So the NAR member MLSs, however, may indicate seller concessions to a buyer. So, for example, in an NAR member MLS, they are removing the field that has co-op fee. For certain, typically that's expressed as a certain percentage of the sale price. They're getting rid of that. You cannot put anything about a co-op fee to a buyer's broker in any of the remarks section. It can't go in the public remarks. It can't go in the private remarks. And in an NAR member MLS, i.e. GAMLS, it can't go in the compensation section. Additionally, you can't attach any documents. You cannot attach anything that says what the co-op compensation, the co-op fee will be. You cannot attach instructions to closing attorney, so forth and so on. But this is where it gets a little bit confusing. You can, in an NAR MLS service, indicate that the seller is willing to give concessions to a buyer. So you just can't say it's a co-op fee to a buyer's broker. You can say something to the effect of, seller will contribute X amount of dollars to buyer's closing costs, or seller will offer a 1-year home warranty, or seller will provide a carpet allowance of blank, or seller offering blank amount of dollars or blank percent of the sale price to be used by buyer in any manner. So that means the buyer could use that seller concession, financial seller concession, to reduce the sale price. They could use it to buy an interest rate down. They could apply it towards their closing costs, or they could apply it to the buyer could apply it to the buyer's compensation obligation to their broker, or they could apply it to repairs, so forth and so on. So again, you can, in the NAR MLSs, like Georgia MLS, you can mention a seller concession, but you cannot specifically state that it goes towards a co-op fee or the buyer's broker's compensation. Contractually wise, you guys, you have to remember, this is regarding this issue or any issue, anything you put, you listing agents, anything you put, or your buyer's agents really, anything that a listing agent puts in an MLS service that a seller is willing to do. For example, pay for a 1-year home warranty, give a carpet allowance, do this, pay anything like that. It is not automatic just because it's listed in FMLS, Georgia MLS, Navica, any of your MLSs. It must go in the contract in order for it to be enforceable between the buyer and the seller. And you buyers agents, if you see on an MLS service that the seller is willing to do this, you need to include it in the contract as a special stipulation, or if it's closing costs or whatever, you need to include that there. You buyer's agents, you also need to make sure, if the buyer's getting a loan, you need to make sure that you get lender approval for any type of seller concession, agent concession, like a commission rebate, things like that. You must get buyer's lender's approval. That's just general. Additionally, NAR members are not allowed to create any alternative system to bypass this provision. In other words, NAR members are prohibited from coming up with a new MLS type service to get around this. So where can you communicate co-op compensation? So the settlement says, yeah, you can still co-op commissions or compensation. It just has to stay out of the NAR member MLS services. So how does all this get communicated? Well, you can put it in your brokers. If I have qualifying brokers on here, you can put it on your brokerage websites. You agents that have agent websites, you can put it on your agent websites. Now, if you get an IDX feed from an NAR member MLS, like Georgia MLS, it's not going to show in there. So you would have to create, for example, especially for the listings that you or your broker offer. You might have to create a landing page on your website that shows these co-op compensations. You can put the co-op fee in any and all of your social media. You can include it in emails. You can have a flyer. You can have it as a handout. You can include signed compensation forms like the instructions to closing attorney, pre-showing compensation agreement. You can communicate it in any manner, text messages, whatever, in any manner you wish, except for it being communicated in an NAR member, a Realtor MLS service. All right, does the MLS compensation field, okay, hang on. I'm looking at the questions now. Regarding seller concessions, should we put it in public remarks or private remarks? I would put it in public remarks so that the buyer is aware in any where the MLSs feed out to the various internet sites. You want the buyers to part of the NAR settlement terms are the buyer has to be completely aware, and the seller, the consumers have to be completely aware of the money. So yes, it would go in the public remarks for the seller concession. If a realtor does the realtor FMLS compensation field violate this agreement? That is a loaded question right now in Georgia, McKay. Let me get to FMLS's statement, and I will address that a little bit later on in the presentation. Peggy, what if someone like Zillow or Realtor.com puts information on the sites without permission? Are we liable? I'm not an attorney, so I'm not going to say an agent or a broker is legally liable or not liable. I will tell you that with respect to third-party websites like Zillow, FMLS, Realtor.com, so forth and so on. I believe this is an issue that the attorneys are going to have to address. Okay, let me actually, I'm going to write this down because that's a great question. And I need to get some more information on that. But here's the issue with that question. That's why this is such a great question. So, my general answer, not being an attorney, but being a broker, and the information I have learned as a broker regarding information published in a third-party website like Zillow, Realtor.com, over which the broker and or the agent have no direct control. We are not directly responsible, at least as far as, well, we are not held directly responsible for misinformation on a third-party website over which you have no control, as long as you can demonstrate that, I'm speaking in terms of license law, because I know this specifically with respect to Georgia license law. Georgia license law regarding advertising, information, and misinformation, and when you have to take active listings down, so forth and so on. Georgia license law states that an agent, they recognize an agent, we have no control over those websites. However, once an agent is made aware that there is misinformation or it's up too long or active on a third-party website, GREC says that an agent must demonstrate, if you're investigated on that, an agent must, or broker must demonstrate to GREC that you have at least made an attempt, a good faith effort, to correct that misinformation. You've made an attempt to contact Zillow, Trulia, Realtor.com and say this information is incorrect, or this listing you're showing is active, has actually been sold, so forth and so on. Regarding this NAR settlement terms, that is a more complicated question. And the reason Peggy is asking this is because the non-NAR member MLSs, let me just talk specifically. FMLS is not an NAR member MLS, and I'm going to get more specifically into that in a minute. They do, as of right now, they are still allowing a co-op compensation field in their service, as well as you can attach documents, so forth and so on. FMLS, as well as Georgia MLS, do have a feed that electronically feeds their information to these third-party national sites like Zillow, Trulia, Realtor.com. So, Peggy, that is a great question. I do not have the answer for that. My answer is couched in terms of what I do have knowledge of as a broker with respect to how that information applies to license law. But this issue, we're going to have to ask attorneys on that one. Okay, let me go back. Great question. Can we go back for the blank that seller is giving concessions? How is that specified? Okay, Sandra, I'm going to cover that when I get to the form, so hang on. Can we just not use MLS and do our listings on Facebook? Great question, Shannon. I'll address that. Let me get to the FMLS and Georgia MLS issues. Matthew, they suggested the safest and best way to do this simple create. Okay, so Matthew is saying that in another training, they suggested the safest and best way to do this is simply create a Google Docs shareable spreadsheet with a list of all your listings and a column for buyer broker compensation and a column that links to the broker compensation agreement form. Then simply a link to this spreadsheet to your website and put instructions in private remarks that instructs agents to go to your website. Click the offer instructions button. Would this be a good way to deal with it for the agent side? I definitely think that creating a shareable spreadsheet or some sort of information, there was nothing prohibited as of this point in the NAR settlement about sharing communication regarding co-op fees per listing. What I hesitate about is putting information in private remarks, telling an agent to go to your website for that information. I think, Matthew, that could potentially be perceived as a violation of this provision that I have on this slide that says NAR members may not create an alternative system to bypass this provision. That's a little bit of a cloudy area. The spreadsheet in and of itself is absolutely allowed as far as where we are today. Communicating how to get to that in the NAR MLS, that's where the gray area comes in. All right, let's continue on. Let me get more to the FMLS, Georgia MLS stuff and some of the actual forms. How all of this stuff works in practice is I've got all the forms I'm going to go through, and then I've got, again, 6 scenarios. So hang with me for that. All right, the fourth key factor. Release of liability for NAR members associations and NAR MLS services. The agreement would release NAR over the 1.5 million active NAR members, all state, territorial, and local realtor associations, all realtor MLSs, all brokerages with an NAR member as a principal whose residential transaction volume in 2022 was $2 billion or less. It releases all of those different parties from liability for the types of claims brought in these cases on behalf of home sellers related to broker commissions. Again, if you are an agent with a company that has their own settlement agreement, if you're a realtor, you are also covered by this. But if your license is with a brokerage that I mentioned, Keller Williams, Remax, anywhere, where they already have an additional or their own finalized settlement agreement, you need to check with your corporate directors regarding the specific terms of those settlement agreements. All right. In Georgia, we have many agents and many brokers who are not realtors. They do not belong to a local board of realtors, Therefore, they do not belong to GAR and they do not belong to NAR. So what about agents or brokers who are not members of NAR? Well, the terms of this preliminary NAR settlement only apply to NAR members. So if you are not a realtor or a member of NAR, I say realtor because the term realtor is a copyrighted term copyrighted by the National Association of REALTORS. So when I say realtor, it's used interchangeably in this presentation with being a member of NAR, because you cannot use that term applied to yourself or your practice if you don't belong to NAR. Now, our public thinks that that term realtor is just a label for our profession in general. Anyone who practices real estate, a lot of consumers think that we're all realtors. We are not all realtors. You have to belong to NAR in order to specifically be a realtor. So you need to check with your broker for any specific questions and changes to any broker policies if you are not an NAR member. In Georgia, an agent is not required to be a member of NAR or to be a realtor to practice real estate. GREC, our state regulatory body, the Georgia Real Estate Commission, they are the body that issues licenses, enforces license law, and at this point in time, they are the body that, again, that governs your license and anything having to do with your license. This is an NAR member, an NAR settlement. So it only covers members of NAR. Again, in Georgia, we have licensees who are not realtors.
Dana, are you able to hear me?
Yes.
I'm sorry to interrupt you. How is this applicable to a broker who is not an NAR member, but have paid the licenses fees to use the NAR contract?
Great question. So again, the terms of this settlement only covers, I'm going to write that one down too. That's a good question. The terms of this settlement agreement apply to NAR members. If you pay an entity, i.e. GAR, obviously, Georgia Association of REALTORS is a NAR member, but you are not paying, you are not a member of NAR. You are paying GAR for the licensing to use their contracts. So as of right now, GAR is allowing non-NAR members to use their contracts. Will that change in the future? I don't know. But as of right now, great question. As of right now, the terms of this settlement agreement, my understanding is do not apply to you. You are not covered from liability. You are not, the terms of this agreement and everything do not apply to you if you are not an NAR member, even if you have paid GAR for the licensing agreement to use their contracts for the year. Great question. I don't know how that's going to change in the future, but that is my answer as of 8/1/24. All right. This is what GAMLS, Georgia MLS. I am just going to, in this presentation, I'm going to go over what GAMLS has said and what FMLS has said. There are many agents in Georgia that belong to a number of other MLS services. You need to check with an MLS service of which you are a member regarding what their practices are regarding all of these issues. But specifically for GAMLS and the NAR settlement, on June 25th of 2024, Georgia MLS came out with a statement that said, in March 2024, the National Association of REALTORS entered into a settlement agreement to resolve litigation related to broker commissions brought on behalf of home sellers. This agreement mandates that covered MLSs adopt and enforce new rules as outlined in the settlement terms. This settlement releases the following from liability regarding claims related to broker commissions: NAR and its over 1 million members, all state, regional, and local realtor associations, all association-owned MLSs, brokerages with principal NAR members whose residential transaction volume in 2022 was 2 billion or less. We've covered all that. As an association-owned multiple listing service, Georgia MLS has opted into this agreement, into the settlement agreement, and is required to implement changes to its rules and platforms by August 17th, 2024. Georgia MLS platforms will no longer include fields for listing brokers' offer of buyer compensation. A specific date for this change will be announced. I am not aware of any date that it has been announced, so they've got just over 2 weeks. It has to be done by August 17th, if not before. Members must not manipulate listings to imply compensation offers through private remarks, photos, documents, or any other fields. Matthew, that's why I am hesitant to your question about the spreadsheet and a Google shareable Google Docs is permitted. However, your last part of your question about instructing agents in the Georgia MLS remarks section to go to that site, that might be perceived as a violation of this last section that says members must not manipulate listings to imply compensation offers. I don't know. That's a question I don't have the answer to. What this means is we've all seen in some Facebook posts and so forth and so on that a listing agent will take a picture, and in the picture, the front picture of the house, they'll have a certain number to sort of wink, wink, nod, nod, indicate that there is, how much a co-op fee is.
Right. What they're doing is that they're just in the private remarks, they're not mentioning anything directly about compensation. They're just saying, visit, www dot whatever and click offer guidelines to view property specific information. That's it. And then when you go there, that same spreadsheet has links to the property disclosures and also other information about the property, like other specific info about it, and they're just including it there. So
yeah,
and they said that it has to be 2 hops, like 2 clicks away. That's what their legal team was saying. So like you can't link directly to the spreadsheet, but you can tell them to go to your website to review property specific information. And then once they're on the website, they click another link that leads to the spreadsheet, and then it's okay. That's what the big firm that was conducting the training indicated that they're doing as their best practice. And they're not allowing their agents to use the FMLS broker compensation field at
okay,
all.
let's stop. Let's I don't want to get into that conversation right now. So yeah. So again, I'm not an attorney. It could be allowed, could not be allowed. It could be gray. We see that in there's a lot of listings that say for more information, go here for specific. So yeah, you need to, for that question, that specific issue, y'all need to check with your specific broker.
Yeah, I just think the whole thing of having like each brokerage make up their own way of dealing with this is going to be the source of the nightmare, where we really, as an industry, drop the ball on like having everyone get together and say the best practice way to do this and still comply is this, and have every single agent in Metro Atlanta trained to do it the same way, so that when I'm a buyer's agent, I know where I can get that information from.
Well, what you're saying there, my understanding is specifically prohibited right here. Members must not, it says NAR members cannot come up with their own system. Let me go back to the previous slide.
Yeah.
That is a specific violation where it said, shoot. NAR members may not create an alternative system to bypass this provision. That sort of thing with all brokers getting together to come up with some other way of communicating this, that is specifically prohibited in the settlement. So again, let's move on. I've got a lot to cover. Generally, if you are on this class, you need to check with your own broker regarding how you as an agent are allowed to address that. Matthew will talk after, and how your brokerage is handling those issues. There's other questions about how to get information prior to showing, any violation if you call. Cheryl, Molly, Zachary, hang on, I'm going to cover all of that stuff as we continue on. Why was public display of compensation found to be prohibited? Again, Jenna, it was perceived as a requirement. Again, there was a lot of the allegation was that it was antitrust and all the brokers were directed by NAR to charge certain commission, and the consumers did not have a say in that, and the compensation was shared. That's the whole nature of antitrust. And again, hang on, I'll address that a little bit further, Jen, as we get further on into the presentation. All right, moving on. Again, we are still on Georgia MLS's statement as of June 25th. MLS participants and subscribers working with buyers must have written agreement before touring a listing. This agreement must specify the broker's compensation, which must be ascertainable and not open-ended. The broker cannot receive compensation from any source that exceeds the amount stated in the agreement. Hang on, I'm going to cover that when we get to the forms. No advertising of services as free. MLS participants and subscribers must disclose and obtain seller approval for any payment offer the listing broker or seller makes to another broker, agent, or representative. Off MLS offers of compensation are permitted. Again, there absolutely is co-op fees are allowed. They just cannot be communicated on a realtor MLS. To align with these changes, Georgia MLS will introduce optional seller concession fields into their listing platforms. These fields will inform potential buyers about contributions your sellers are willing to make as part of the transaction. Again, I addressed that earlier. It cannot specifically say that the buyer can use it for any compensation or commission for their broker or agent. It can just say X amount of dollars, use it how you will, or off closing costs. I've already addressed that. All right, now let's get to FMLS. So Georgia MLS is an NAR member MLS. They are owned and operated by a board of realtors and are have opted into this settlement and absolutely are required to follow the terms of the settlement. FMLS, First Multiple Listing Service, let me read what their statement was as of June 18th. I have not seen any updates to this from FMLS since then. And again, there was a date in June when any non-NAR member, broker, or MLS could opt into the settlement agreement. That date has come and gone. Will it be opened again? I don't know, but as of right now, FMLS, well, let me read you the statement. Many members have inquired as to FMLS's position on litigation against NAR settlement, and FMLS system changes that may result from continued litigation surrounding broker compensation. Let me parenthetically tell you guys too, in Georgia, there is still an active Georgia lawsuit regarding these issues ongoing. It has not been settled or dismissed. It is still an active ongoing lawsuit here in Georgia. So how does all of this interact? You've got the NAR settlement agreement. You might be with a brokerage that has their own settlement agreement. You might be a realtor. You might not be a realtor. You're practicing in Georgia. We have our own lawsuit. How do you work with all of this stuff? There are a lot of moving pieces, rules, regulations. Even the NAR settlement, as I've repeatedly mentioned, does not have final approval. So staying informed is going to be key for you as an agent. Just wanted to say that. So, all right. FMLS is not planning to join the proposed settlement in litigation involving NAR. FMLS is broker-owned and not affiliated with NAR. As FMLS members know, our rules have long and explicitly stated that FMLS is in no way involved in determining the compensation charged by real estate brokerage firms or the commission split between cooperating real estate brokerage firms. FMLS has no plan to change that long-standing established position. However, in light of recent industry discussions and activity, FMLS plans to make the following enhancements. On the MLS listing platform, FMLS will introduce a new concessions field, as well as an option for the listing agent to communicate that a seller will be willing to pay compensation to the buyer's broker, and inviting buyers to include any requested compensation for the buyer's broker in the buyer's purchase offer. At this time, all other fields will remain in place and unchanged, i.e., FMLS still is going to have a co-op compensation field that is a fill in the blank that is usually reflected as a % of the sale price that the listing broker is willing to share with a buyer's broker, should that buyer's broker be the procuring cause of sale and you go under contract and sell the house. FMLS intends, hang on one second. FMLS intends to update its rules and regulations to formalize existing practices forbidding false representations on the MLS that brokerage services are free, and reinforce the practice of prohibiting filtering MLS listings based upon the offer of buyer broker compensation. Through MLS data feeds, progressive rules, and continued availability of field in the MLS, FMLS will continue its practice of promoting transparency, accountability, and auditable electronic records. Peggy, I interpret that as meaning that FMLS's data feed, including their compensation field, will still go out to those third-party websites like Zillow, Trulia, Realtor.com. So that is an issue, not only in Georgia where FMLS is independent, but there are other MLSs throughout the country that are independent, and I imagine they're going to be facing the same issue. So I think that's going to be a stay tuned. Let's see what happens with that one. Finally, FMLS also plans to update the RE forms in line with industry form changes. More information on these practice changes and any other FMLS rule changes will be communicated in advance of such changes taking effect. Now, here is the FMLS's here are the FMLS rules on compensation. Buyer agency offer of compensation. There is a field, this is directly from, this is not Dana slide, this is verbatim copied and pasted from FMLS's website on their rules on compensation as of today, as of last night. Buyer agency offer of commission. There is a field on every listing, buyer agency compensation, which notifies the buyer broker agency of what is offered by the selling broker agency if they participate in a sale of that listing. The buyer agency compensation can be entered as a percentage of the sale price or a specific dollar amount. If there is a potential reduction in the compensation payable to cooperating brokers or the method by which the possible reduction in compensation will be calculated, it must be clearly communicated to potential cooperating brokers before the time they submit an offer. Additionally, that means you listing agents, you should in FMLS where it has VRC, which stands for variable rate commission, You absolutely should mark yes on every listing that offer of compensation is variable based on any number of circumstances. If there is a potential reduction in the compensation payable to cooperating brokers or, I read that one. Any comments relating to commission or compensation appearing in the public remarks must include to selling broker and not to selling agent. All right. Well, let me move on to this slide. All right, now let me back up. Okay. There are a lot of questions, comments, talking points throughout the brokerages, various closing attorneys, regarding Georgia and FMLS's rules, and I imagine this applies to other independent MLSs throughout the country. As of right now, FMLS, as I've just read, is no changes. Well, there are changes in that they're creating an additional remark section that is compensation section or seller concessions section, and Georgia MLS is offering a seller concession section. On FMLS, as of today, you can attach a document just like you attach your seller's property disclosure form or community association disclosure exhibit. You can attach pre-showing commission and compensation agreement, instructions to closing attorney. You can do that on FMLS as of right now. You cannot do that on Georgia MLS because they are an NAR member MLS, and that is prohibited. So the question becomes, as an agent, what do you do? If you have a listing agreement signed where the seller does approve of you co-oping a compensation, they're going to pay you X amount of dollars as compensation, and of the money they pay you, you are allowed to share part of that or as a co-op compensation fee with a buyer's broker. So that is agreed to in the seller's listing agreement. The seller agrees to that. We've already stated you can communicate that outside of any MLS all day long. I'm going to show you guys, Matthew's brought up a great point of how to do that. I'm going to show you in the GAR forms, additionally, how you can do that. The question becomes, what do you do if your broker belongs to FMLS and Georgia MLS? Let's say you're a realtor, you're an NAR member, so you you have to adhere to the preliminary NAR settlement, but your broker is also a member, you're also a member of FMLS. That has certain rules that say, number one, you can't put zero, or you can't communicate that it's zero or free. And then we also have to adhere to license laws here in Georgia that say there can be no misrepresentation of a listing. So what do you do? I'm not going to answer that question. And like I said, there are a lot of brokers saying one thing, closing attorneys saying one thing, and there are a lot of brokers and closing attorneys saying exact opposite things. There are, I am just going to say, for the purposes of this class, you as an agent need to check with your broker and find out what your broker's guidelines, policy, procedures are regarding that issue on whether to list in FMLS's rules do say if you have an exclusive listing agreement signed with a seller and that property is located in an FMLS compulsory area and you are a member of FMLS, you are required to put that listing in FMLS. So there was one question about, can you just not put it in FMLS? That is a violation of the FMLS membership agreement. So if your broker is a member of FMLS, again, I'm not going to belabor this point. I want to get onto the forms. These questions are very important questions, and you need to have conversation with your broker. You all need to be in touch with your brokers right now. Go to your sales meetings. If your broker communicates with you via guidelines, manuals, online resources. If you have not been in touch with your broker for a while, now is the time to find out specifically regarding, this is the biggest issue facing a lot of agents here in Georgia, because FMLS is, my understanding, is one of the largest MLSs in the entire state, and it has not opted in to the MLS guidelines, so you can put compensation. So business as usual with FMLS, and it's important, as you'll see as we move on, it's important for a buyer to know if there is a co-op compensation, and I'll get into that in a minute. So there is a question about why a certain company is implementing their own policy. It has nothing to do with FMLS's policy. Well, companies are allowed, brokerages are allowed to have policies, and agents are allowed to go to different companies if they don't agree with the policies regarding anything. If a certain brokerage has a policy that goes against an MLS's guidelines, that's going to be between, that's going to be between that MLS service and that brokerage. That is not for me to comment on. Overwhelming, yes, it is. Matthew is asking about a specific brokerage. We have a guide that I will share with you. We have a brokerage guide to how our agents are to move forward in light of these. For clarity reasons, these settlement changes are only applicable to NAR members. Yes, that is correct. NAR members or non-NAR members who have chosen to opt in, which would be a non-realtor brokerage or non-realtor MLS service. All right. Woo! Let's move on. Putting all of this into practice. You guys, Georgia is years ahead. According to GAR, we are approximately 10 years ahead of many, many other states in regards to laws about practicing real estate, our contracts, our GAR contracts, and addressing many of these issues. Buyer brokerage laws. Y'all, believe it or not, there are only 18 states that have laws about buyer brokerage representation. Georgia is one of them. GAR contracts have a 2-year statute of limitations for a consumer to bring a lawsuit, basically, a complaint. GAR contracts include language prohibiting sellers from participating in class action lawsuits. GAR contracts provide for negotiation of seller-paid compensation and have for years. GAR contracts provide for negotiation of buyer-paid compensation and have for years. Not as many as we've had the sellers have to agree, fill in the blanks and agree to compensation, but the buyer compensation section has been in our buyer brokerage agreements for years. GAR contracts provide for negotiation of co-op paid compensation, and in the listing agreement has had that for years. GAR contracts have been revised on July 1st of this year to fine-tune the compensation issues raised by the preliminary NAR settlement. FMLS and GAMLS allow broker and agent members to utilize their services without being required to join any particular association of realtors. Oh, I gotta catch my breath. So a couple of things. Number one, when y'all are listening to all of these national conversations, some are, some aren't. When there are a lot of Facebook groups that have realtors from all over the state, there's websites, podcasts, YouTube videos, real estate coaches. You have to remember that these national conversations are attempting to address this whole issue nationally. In a lot of other states, in the seller brokerage agreements and the buyer brokerage agreements and customer agreements, there are no fill in the blanks for any commissions or compensation paid. The broker charges whatever they charge, and the seller doesn't agree to it in writing or not. There's nothing where a seller agrees or does not agree to a broker, the money the seller's paying the broker for compensation, to share that with the buyer's broker. In the buyer brokerage agreements, there's no compensation. So you guys, some of this stuff doesn't make sense to us. And we're thinking, why on earth is this going on? Because our contracts and our brokerage laws are brokerage laws, buyer brokerage and seller brokerage laws. We've had this stuff. We've already been dealing with this stuff for years and years and years and years. A lot of these issues are brand new to many agents and many markets throughout the country. Additionally, I don't know about the majority. I'll just say the majority. I'll just say many MLS services throughout the country, even in other parts of Georgia, rather than Metro Atlanta right here, their MLS services are owned and operated by a particular board of realtors, and an agent and a broker must be a member of that MLS service to cooperate with another broker. In other words, in other parts of Georgia and throughout the state, throughout the country, if a listing is in a particular MLS service, and in the past they've had a co-op fee of X% of the sale price, if you and your broker don't belong to that MLS service, but you have a buyer that buys that house, they're not obligated to pay. You have to be a member of that board of realtors to participate in the MLS service and to have any co-op compensation from that listing broker. So here in Metro Georgia, a lot of this stuff doesn't even click with us because FMLS is independent and has been independent since their existence. Georgia MLS is sort of a hybrid. Georgia MLS, in many ways, operates as if they're independent, yet they are a realtor-owned MLS service. So Georgia MLS has changed and morphed throughout the years, but neither FMLS, anybody can join. You don't have to belong to any certain brokerage. You don't have to belong to any certain board of realtors. You don't have to belong to any board of realtors. And you can join FMLS and be a member and share your listings and have co-op compensation, so forth and so on. And prior to this NAR settlement, if there was a listing of co-op compensation in FMLS or Georgia MLS for that matter, prior to this, you could, that did act, you could rely on that. The broker could rely on that. You needed to get it in writing, but that was something that was in essence an agreement for compensation between the brokers. Georgia MLS, again, is association owned and NAR member. However, they also have morphed to the point where they do not require a broker or an agent to belong to any particular board of realtors or even be a realtor at all to join their service and utilize their MLS service. So here in Georgia, in Metro Georgia, a lot of this stuff is way overwhelming because it just makes sense to us. That's how we've always practiced. So I just want you to be aware of that when you are listening to all of these national conversations. Okay, let me look at the questions. We'll move on and then we're going to take a break. So with each showing, we need to ask the listing agent if they're offering a co-op or not. What should be the exact words in the buyer brokerage? Great question, Jigishaw. Hang on, I've got the forms. I'll show you how to fill them out and what to do. Peggy, the GAR contract regarding 2-year statute of limitations is only for Georgia, or does it pertain to a federal statute? Nope. Not only is it not, it's not law. It is just a contract provision. So Peggy, it is just if the parties are binding on a GAR contract. Unless the RE forms have been changed lately, and if you're like on a new construction contract, HUD contract, Fannie Mae, Freddie Mac, an attorney written contract, that statute of limitations language is not in there. So regarding Georgia state law, regarding bringing up a lawsuit, a statute of limitations on this in a civil case or federal, I'm not an attorney. but my understanding is I don't know what the laws are regarding a statute of limitations for bringing a lawsuit in a civil case. But I don't, well, I would imagine it's not even a state law in Georgia, because the Georgia lawsuit that is on the books right now, the plaintiff's attorneys are going back 4 years. So that leads me to believe it's not a state law. And I do not believe it is a federal law. I believe there are very few, well, I'm not even going to go into that. I'm not an attorney. But it is not a law. That is just a GAR contract provision for parties binding on a GAR contract. What if I'm not a member, but your broker is? If you are not a member of NAR, but your broker is, you are not a member of NAR. So the broker is responsible for you adhering still to the NAR Code of Ethics, and your broker has to pay NAR fees for you, but you are not a member of NAR, even if your broker is. Good question. If a class action lawsuits are prohibited by sellers in Georgia, why is the lawsuit going on? Okay, great question. So all of these things that you read, even in any of the contracts where it says, the remedy for default is, for example, earnest money and no lawsuit, or you hear anybody in any presentation saying they can't sue, or you're protected from liability. You guys, anybody can sue anybody for anything. So just because something says you can't sue doesn't mean you can't sue. What that means, so the question that Molly brings up is, class action lawsuits are prohibited by sellers in Georgia. Why is the lawsuit going on? Well, the sellers can still sue the brokerages and NAR here in Georgia. That verbiage gives the plaintiff's attorneys something to argue in front of a judge. So the attorney is going to go in front of the judge and argue that when the seller signed that contract, it was in there and that's what the seller agreed to do. Ultimately, regardless, it's still up to the judge to interpret that and make a decision regarding that issue. So just because it says they can't, that basically just gives the attorneys the groundwork or the argument to make the argument in front of a judge. As I mentioned, a judge can say or do anything they want. As a matter of fact, in the GAR purchase and sale agreement itself, there is a paragraph that states, regardless of the intent of GAR and regardless of the intent of the buyers and the sellers and the brokers and the agents who sign that contract, there are that a Georgia court can make their own interpretation of the contract and what has been signed and make a ruling based on their own interpretation regardless. So GAR even has that admonition in the GAR purchase and sale agreement in and of itself. All right. Putting this all together, let me see where I am to where we're going to take a break. Okay, this is a good place for a break because this next section is, I'm going to stop the share. This next section is where I'm going to actually get into the forms and answer a lot of these questions that you guys are asking. You guys are asking a lot of specific questions. How do I do this? How do I ask? What do I do? So forth and so on. So this is a good place for a break. It is 11 o'clock and I need to get something to drink. So let's take a break and come back at 11:15. All right, everybody. Thank you so much. Welcome back. I appreciate your time. We are going to switch gears a little bit and talk about, okay, we could talk about all of this theoretically for hours and hours and hours, but I want to switch gears and get into the nuts and bolts. Okay, what do we do with this information? You're an agent here practicing in Georgia. Now what do you do? So that's how we are going to continue. And so here we go. I'm going to go back and share my screen again. And I believe, let me find the share screen. A lot of the additional information should answer a lot of the questions that have come up regarding what do you do now? How do you find out this information? again, so forth and so on. Let me get this out of the way. I want to do that. All right. So putting this all into practice in Georgia, we have to start with here in Georgia. How are real estate agents paid? How are real estate professionals paid? In general, how are agents paid for the professional services they provide? Agents, you guys are all paid via the terms of your independent contractor agreement that you have signed with your broker. So how are brokers paid? Well, brokers are paid by the public, our buyers and sellers. Now, landlords and tenants pay us too, but the settlement agreement is just with respect to residential sales, as is this presentation. So it is important for you, the agent, also known as the affiliated licensee, to make sure that your broker gets paid, that the broker's compensation is agreed to in writing by the parties paying the compensation. Your broker has to get paid in order for your broker to pay you. Couple of notes on compensation. Compensation agreements must be signed by the parties paying and receiving the compensation. An offer of compensation in a website, social media, email, text, MLS listing, so forth and so on, is not binding until a written agreement is signed by the parties involved. Note, many articles, presentations, videos, and forms, again, I mentioned this at the beginning, will interchange broker and agent or affiliated licensee. Broker and agent compensation amounts are not set by state law, and they are negotiable. A brokerage may have a policy regarding compensation amounts they will accept for the professional services they and their agents render to consumers. Okay, so let's start at the beginning. We wouldn't be in business if we did not have somebody that wanted to sell a house. So how is the seller's broker paid? The seller's broker is only paid by the seller. Now, that relationship between the seller and the seller's broker is either that of client or customer. So where is this seller paid compensation agreed to, negotiated and agreed to in writing? Well, if you are working with the seller as a client, it is on the exclusive seller brokerage agreement or the non-exclusive seller brokerage agreement. If you're working with the seller as a customer, it is all negotiated and agreed to on the authorization to show unlisted property. So seller's broker paid by the seller. Now let's talk about a buyer's broker. How is the buyer's broker paid? Well, the buyer's broker is paid one of three ways. The buyer's broker can either get paid by the buyer, the buyer's broker can get paid by the seller's broker, or the buyer's broker can get paid by the seller. So three ways a buyer's broker can get paid. Where in our forms is all of this worked out, negotiated, agreed to, and signed in writing? If a buyer's broker, and again, your broker has to get paid so your buyer's broker can pay you, the agent, but agent, broker get paid by the buyer. If you're working with the buyer as a client, if that's the nature of the relationship between your public buyer and your broker, then this information, this compensation is negotiated and agreed to on an exclusive buyer brokerage agreement or a non-exclusive buyer brokerage agreement. If you are working with the buyer as a customer, this is all negotiated and agreed to on the agreement to work with buyer as a customer. I parenthetically will let you know, in the GAR, Georgia Association of REALTORS contract package, the buyer customer agreement up until July 1st of this year has been the only document with respect to initiating services, working with a public buyer, public seller that has not had compensation in there. It does now as of July 1st. If the buyer's broker is being paid by the seller's broker, where is this all negotiated and agreed to in writing? Three places: pre-showing compensation agreement, broker compensation agreement exhibit, which is a brand new form as of July 1st, and instructions to closing attorney. So one of those 3 documents is where we know how a buyer's broker and how much is being paid by the seller's broker as a co-op fee, co-op compensation. Now, what if a buyer's broker is being paid by a seller? Where is that all negotiated and signed? That is done via the purchase and sale agreement, either as a special stipulation, as a part of closing costs, or I probably should also have put on here the broker compensation agreement exhibit. But you'll see as we get into these forms. So, did I skip one? The GAR buyer agreements. Where do I not have the seller? Shoot, I thought I had the seller agreement. Did I skip one? All right. I apologize. I thought I had, let me just show you guys the seller agreement. Because I thought I had that in here and I don't have it in the slide. So let me show you the seller agreement form. This is I'm just going to show you the exclusive seller brokerage agreement. All right. Here in this section, this is a revised form, revised as of July 1st. This is the seller brokerage agreement form. Remember, seller's broker is paid by the seller. In the seller brokerage agreement form, compensation for broker professional service, compensation to brokers is negotiable and is not set by state law. However, that is new verbiage in direct compliance with the terms of the preliminary NAR settlement. However, this does not obligate individual licensees and brokerage firms to necessarily negotiate their commission. And then there is a place in the seller brokerage agreement, compensation to seller's broker. Seller agrees to pay seller's broker the following compensation, expressed as a % of the sale price, a flat fee, or other.
Dana, were you intending for us to see that?
Yep, sorry.
Okay.
Thank you. Thank you very much. There we go. Okay. Seller, this is the listing agreement, seller brokerage agreement, paragraph A4. I have it somewhere in my slides, but it should have been next and it's not there. So compensation of brokerage agreement compensation of brokers is negotiable and not set by state law. However, this does not obligate individual licensees and brokerage firms to necessarily negotiate their compensation. Next section, compensation to seller's broker. Seller agrees to pay seller's broker % of the sale price, flat fee, other. Optional, compensation to buyer's broker. Seller hereby approves, this verbiage is to stay in compliance with the terms of this settlement. Seller approves the following compensation, if any, being paid to the buyer's broker.
This is not.
Either, I'm going to mute everybody. Either by the compensation of the buyer's broker is either by the seller in addition to what they're already paying their broker, or compensation to a buyer's broker, the seller approves of the buyer of their own broker paying it from this amount that they're paying, or they're sharing it. And so this would be, for example, this, if the seller, like we are, like many agents are used to doing, seller pays their broker X amount of dollars or X % of the sale price and says, I want you to share part of that or co-op part of that with a buyer's broker, and this is how much you're allowed to. So if that is the case, this amount up here is larger than this amount here. And if there are certain conditions, it goes here. Then it says to disclose to the sellers. For all purposes herein, the term buyer's broker shall mean broker including the broker representing the seller if they're also working with or representing the buyer as a customer or client. That verbiage is in there in case you as an agent have both sides of a deal and you're working on the seller side and on the buyer side. Then in the corresponding paragraph, again, this is the exclusive seller listing agreement. It says, in the event seller enters into a contract, they are obligated to compensate their broker the amount just specified in that previous paragraph. Then it goes on to say, seller shall have no obligation to pay the compensation to the buyer's broker. However, some sellers approve such compensation being offered and paid for by either the seller or the seller's broker. If the seller has agreed to pay compensation to the buyer's broker on any contract, it shall be paid in full at closing. If the seller does not approve of paying compensation to the buyer's broker, then the buyer shall be solely responsible for paying the buyer's broker's compensation. Now, don't get confused. If the seller agreed to this fill in the blank here, they can't change their mind. If they don't want to pay a co-op, if they don't want you to pay a co-op fee, or initially decide they don't want to pay compensation to a buyer's broker, then that would be, those would be filled out as zeros. If there are dollar amounts or percentages filled out there, this is what they have to do. All right, let me go back to the PowerPoint because that should have been first. Now let's talk about the buyer agreements. Again, so the seller's broker gets paid from the seller. On that form, that's where it's described, negotiated, and agreed to. Now, for the buyer side, if a buyer is paying the buyer, okay, let me even back up further. The NAR, in terms of the NAR settlement, says all buyers must sign some agreement with a broker that discloses their financial obligation prior to ever seeing any house. So what do you sign? Well, you would either sign an exclusive buyer brokerage agreement, a non-exclusive buyer brokerage agreement, or agreement to work with buyer as customer. Any one of those three agreements complies with the NAR preliminary settlement. How you fill those out, those can vary in amount of compensation, length of time. You can identify specific properties. You can limit it to a certain number of properties. You need to check with your broker's policy. In other words, the settlement says you have to you have to sign an agreement with your buyer before showing a property. But you or the buyer might not be comfortable signing a full-blown buyer brokerage agreement for an extended period of time. So maybe you fill it out for a week or 2 weeks, or maybe you fill it out and say, this is just in effect for the showing of 5 properties. Or maybe you fill it out and it says, this is just in effect for the showing of a certain property. So you need to check with your broker's policy on the leeway that you have in filling these out. But any one of these 3 documents satisfies the terms or is in compliance with the terms of the NAR settlement. And like any contract, these could be amended at any time. So here is the compensation section in the buyer brokerage agreement. This verbiage is exactly the same in the buyer customer agreement as well. Very, very similar to what we just covered in the seller side, but a little different. So generally, compensation of brokers is negotiable and is not set by state law. However, this does not obligate individual licensees and brokerage firms to necessarily negotiate their commission. Buyer agrees to pay buyer's broker the compensation set forth below at the closing of any contract to purchase. And that is expressed as a % of sale price, flat fee, or other. Again, per the NAR settlement, this may not be 0% and may not be $0. Next paragraph. Buyer hereby approves or disapproves, this is to be in compliance with these terms, of the buyer's broker receiving compensation from the seller or seller's broker. So first of all, the buyer has to approve if you can even get paid by the seller side. Nothing herein shall be interpreted as a promise by the seller or seller's broker to pay or offer to pay herein. If the buyer does approve of such compensation being paid by the seller and or seller's broker to the buyer's broker, the maximum amount the buyer's broker may receive from the seller and or seller's broker is, and you fill this out. Again, to be in compliance with the terms of the settlement, the buyer has to agree to a maximum amount that your broker and you can get paid by the seller side. What does that mean? That means we know there are some sellers, there are some new construction companies out there that are offering bonuses, so forth and so on. So a couple of things. Never leave this blank, number one. Number two, it cannot be open-ended. You cannot put in here any amount offered by seller side. That's not, you can't calculate that. That's open-ended, and that is against the terms of this settlement. You also, but you don't want to leave it blank, and this amount should be larger than this amount to account for any bonus offered by the seller side. I'm going to show you this in practice in just a minute. Next section, possible reduction in the buyer's compensation obligation to their broker. Any compensation the buyer's broker receives from the seller or seller's broker shall reduce the compensation the buyer's obligated to pay, not reduce it, or special exceptions. What does all that mean? I think I have it in practice later, but for the most part, most buyers are going to want to, whatever they have obligated themselves to pay you at closing for your professional services. If the seller side is also paying you, they want this amount to be subtracted from what they owe. So so more than likely, buyers are going to agree to any compensation you get from the seller side is going to come off of or reduce the amount they have obligated themselves to pay you at closing. Hang on, I've got specific examples as we move on. Okay, let me look at. Always having a rule about getting buyer agency agreement signed. Okay, so a question. Many have always had a rule about getting a buyer agency agreement signed prior to showing homes, but historically many agents have not complied with this and there was no enforcement of it. Is that still the case, or is more strict? So the terms of the NAR settlement, if you are a realtor, you are now required to get some agreement signed by your buyer prior to showing a property. It can either be, as I mentioned, a buyer brokerage agreement or a customer agreement. Are people going to cheat and not get it signed? Well, couple of things. Number one, as we mentioned, the terms of this NAR settlement are for NAR members or realtors. Number two, even NAR or realtor members, let me ask you a question. I don't want anybody to answer, but I want you to think for yourself. What is the posted speed limit on 285? Have you exceeded that? So, don't know.
I was actually asking that from the perspective of it always bothered me and made it, when there were so many agents out there that were not, I've always gotten them signed, but there was so many agents that were doing it without signing that I had a lot of people tell me, well, I'm just going to go with this other agent because they won't make me sign anything. So the fact that if they're actually clamping down on that and enforcing it, I'm actually that's the one good thing that has come out of this.
Yep. So, and I address that a little bit later on. So, you bring up a good point. The enforceability of these rules is an entirely different issue. But I am gonna address that later on when we get to the end of the presentation. Yes, if you have any suggestions to the GAR Forms Committee, you need to contact GAR. there are a lot of changes that are going to occur for the GAR contracts for January. Unrepresented buyer versus customer might change, and they already have changed all of that moving forward. Again, you guys, as McKay reminds us, you need to check with your own brokers on policies, procedures, and guidelines that your brokerage is requiring of you as an agent affiliated with them. But let's move on. The corresponding paragraph in the buyer brokerage agreement states that buyers shall be obligated to pay the buyer's broker the compensation referenced herein at closing. Goes on to talk about the protection period, so forth and so on. And then it says compensation in any real estate transaction is negotiable and can be paid by any of the parties in a real estate transaction. There are times when the seller or seller's broker in a real estate transaction may offer to pay the buyer's compensation obligation of the buyer's broker. This is the buyer-customer agreement, and it is the exact same verbiage as in the buyer brokerage agreement. Okay, I just have them out of order. I don't know why, but here's the seller agreement. We've already discussed that. So again, the seller agrees in the exclusive seller brokerage agreement, non-exclusive authorization to show. Any one of those agreements complies with the NAR preliminary settlement. These may vary in amount of compensation, length of time, etc. Check with your broker's policy, and they may be amended at any time. This is what I showed you in the form itself. We talked about that. This is the GAR, when you're working with a public seller as a customer, they sign the authorization to show unlisted property. This form was not revised in July by GAR. It will most likely be revised, and commission will definitely change to compensation. Right now, this does not have anything about the seller customer co-oping, agreeing. They just agree to pay you your broker compensation. There's no verbiage in here about paying or cooperating, you sharing that commission with the buyer's broker, because there's not typically, if you are working with a buyer, typically an agent or a broker working with a seller customer isn't in a listing situation where there's a co-op situation. Usually they have both sides of the deal, but this more than likely will definitely get addressed in January. Also in January, GAR has put in, you guys, you have got to use these consumer brochures with your public people. You need to get as confusing as this is to us, it's confusing also to our public. And you've got to get into their hands as much written information as you can to be able to demonstrate that you've done your best to educate your public. So in the two GAR consumer brochures, protect yourself when selling real property and protect yourself when buying real property, in July, GAR added a whole new paragraph on broker's compensation for professional services. A broker's compensation in Georgia and who pays it is always negotiable. Compensation can be paid by the seller, the buyer, or both. Some buyers will ask the seller to pay the compensation the buyer owes to the buyer's broker. They may do this for a couple of reasons. First, if the buyer's getting a VA loan, the buyer may not be permitted under the loan program to pay the buyer broker's compensation. A note, in June of this year, the VA have modified their rules and regulations. At any particular point in time, if you are working with any buyer getting a VA insured loan, FHA insured loan, or conventional loan, you need to check with the lender regarding the most current rules and regulations regarding paying compensation, financing compensation at that time. So that's has already changed before this was published. Others, particularly first-time home buyers, may not be able to afford to pay the buyer's broker's compensation if it is not included in the buyer's mortgage loan. When a buyer asks the seller to pay the compensation owed by the buyer to the buyer's broker, the buyer is effectively making the compensation part of the sale price for the property, because most sellers will focus on their net proceeds after the broker's compensation is paid. When the seller is not initially offering to pay the buyer's broker compensation and the buyer wants the seller to pay this obligation, the buyer will usually include a special stipulation to that effect in their offer to purchase the property. If permitted by the buyer's lender, the buyer can also request the seller to make a monetary contribution at closing, as per the GAR purchase and sale agreement, which can then be used by the buyer to pay for, among other things, compensation owed by the buyer's broker. This will probably be tweaked again in January, but this is GAR's verbiage in their consumer brochures. Hang on, we are going to get to more how to do this. There are 3 additional compensation forms in the Georgia Association of Realtors contract package. The pre-showing compensation agreement, which used to be called co-op commission agreement to be used prior to showing. This has been in existence for a long time. Agents rarely used it. This is probably going to be your new best friend, at least for the foreseeable future. A brand new form called broker compensation agreement exhibit, which is an exhibit to the contract, and instructions to closing attorney, again, which you guys are used to seeing. So let's talk about this form, pre-showing compensation agreement. And it says, basically, you identify the property, and this says the seller and seller's broker, depending on who is paying the compensation to the buyer's broker, confirms to the buyer's broker the compensation for professional brokerage services to which the buyer's broker is entitled if the buyer, in the event the buyer with whom the buyer's broker is working with or representing so this verbiage, working with or representing, that Peggy, is working with means you're working with that public buyer as a customer. Representing means you're working with that public buyer as a client. So there is that distinction right there. Instead of unrepresented buyer, they have working with or representing. So that's code, agents. That means you've signed a customer agreement. Representing means you've signed a buyer brokerage agreement. The agreement is contingent upon the offer being made through the buyer's broker, being delivered to the seller's broker within so many days of that date. Then it goes on to say, here's the compensation. So again, agents, this is the form you use to get in writing if the listing broker is doing a co-op fee and sharing part of their commission with you. You want this in writing to know how much at closing the seller's broker is paying the buyer's broker. So compensation being offered to the buyer's broker. How much? Expressed as a % of the sale price or dollar amount or other, and who is paying it. This is coming from the seller side. So is it coming from the seller in addition to how much the seller is paying their own broker? Is it coming from the seller's broker out of the compensation that they're being paid by the seller? Or is it in combination, the buyer's broker is being paid partly by the seller and partly by the seller's broker? Hang on, I'm going to show you how this works in just a minute. And then it goes on to say, there's no brokers, we get no compensation if there's no closing. Buyer's broker and all other parties can rely on this offer of compensation and it is binding if it is signed. Pre-showing compensation shall not modify, amend any separate agreement regarding buyer's broker compensation. That means this does not change the buyer's obligation to pay you that they agreed to in their buyer brokerage agreement. But if they agreed that any money coming from this is just money coming to the buyer's broker from the seller side that you get signed before showing a property. Look at this paragraph G. This is why in the buyer's brokerage agreement, it's important to fill out that maximum amount. If the compensation being offered to the buyer's broker is more than the buyer's broker is permitted to accept, and the buyer does not consent to the additional compensation being paid, then the offer of compensation herein shall be reduced to the amount that the buyer's broker is permitted to accept. And if you sign this as a licensee, you warrant you have your broker's permission. Okay, question. Who initiates this form? This form, in practice, I think a seller's agent should have this filled out. And I have best practices towards the end. If you do not have this information, then the buyer's agent is going to want to initiate this form. In what scenario is it beneficial for part of the compensation to be paid by the seller? Hang on, I'm going to address that, Jenna, as we get to some of the other forms. And then there are places to sign. Now, the buyer's broker and the seller's broker sign. So this first part, you guys, this is very similar to instructions to close, the second part of instructions to closing attorney. This is how much is the buyer's broker being paid from the seller side? Generally speaking, this would most likely be from the seller's broker. So the buyer's broker and the seller's broker sign it because this is how much the seller's broker is agreeing to pay the buyer's broker. There is, however, a section down here for the seller's signature. Again, this is not an exhibit. This is a pre-showing compensation agreement, not an exhibit to a purchase and sale agreement. This is a document signed before you ever show a buyer a property. There is a place for a seller's signature. However, if the seller is paying the buyer's if the seller agrees up front to pay the buyer's broker directly, then the seller would sign this. The seller, it's all in caps. The seller does not need to sign this agreement if all compensation to be paid herein to the buyer's broker is being paid by the seller's broker. So more than likely, you're just going to have the two agents sign this. Here's the next form. Hang on, I'm going to show you how these guys work, how these work in practice. This is the next form. This is a brand new form as of July 1st from GAR. This is an exhibit to a purchase and sale agreement called a broker compensation agreement. I have my note here, and I'll tell you why I have my note here. My note says, if instructions to closing attorney or the document we just covered, pre-showing compensation agreement, have already been signed, you do not need this form. And why do I say that? Why do you say that, Dana? This is why I say that. This agreement should not be used if the broker's compensation and the party or broker paying it have already been agreed to in a separate written agreement and is not being modified. So if you already have instructions to closing attorney signed by listing agent and buyer's agent, or pre-showing compensation agreement signed by listing agent and buyer's agent, and it's not changing, you would not use this exhibit in your purchase and sale agreement. So this is not something that you are going to use in every offer, buyer's agents. You don't need this if you already have the pre-showing compensation agreement. However, if you do not have anything signed confirming how much the buyer's broker is getting paid from the seller's side, and the buyer wants to make an offer on a property, you are probably going to want to use this exhibit. So you fill in the date and the buyer and the seller and the property, and it states, this form also I know is going to be changed in January because it's confusing. Basically, it states that the compensation being offered to the buyer's broker, the compensation to the undersigned broker and professional brokerage services provided the above referenced transaction is set below and paid by the following. Again, how much and who is paying. So this is how much is going to the buyer's broker, expressed as a percent of the sale price, flat fee, or other. If solely it is the buyer paying your commission, the buyer agreement has already been signed. So you wouldn't use this form. because the buyer has already agreed to that. So if you as the buyer's broker are not getting paid from the seller side at all, you don't need this form. You already have the buyer agreeing to pay you at closing in the buyer brokerage or customer agreement. If, however, you are being paid a co-op fee from the listing agent or paid directly by the seller and you don't already have that signed, you would use this. And you're going to put, if it's only a co-op, you'll put the dollar amount paid, and it's paid by such and seller's broker, ABC Realty. If you're only being paid by the seller, it's going to be how much paid by the seller. If it's in combination, then you're going to spell that out. Again, hang with me. I've got an example. The next part of this form is really confusing, and GAR is going to eliminate this section in January. That should say 2025. This also has how much is the seller's broker being paid. The reason this is confusing is this is an exhibit to a purchase and sale agreement. So who initiates a purchase and sale agreement? Typically, it is the buyer's agent on behalf of the buyer that initiates an offer and would include this exhibit. Well, if you don't even know if there's a co-op fee for your commission, you certainly don't know how much the seller has agreed to pay their own broker. So this puts you buyer's agents in a precarious position. How do you fill this out? And if you don't know, it might put your buyer in a precarious position of requiring a seller counteroffer rather than being able to go binding with an initial offer. So that's why GAR is going to take this out in January. Nevertheless, it's how much is being paid to the seller's broker and by whom. And again, this will be the seller, but this is what I just mentioned. That's why GAR is going to eliminate this. Again, this is enforceable and binding upon the parties. Okay, this part's important. This is an exhibit to the agreement. However, this verbiage right here is really, really important. And I'll tell you why in just a few slides. But it says, this agreement is enforceable and binding upon the parties and brokers signing the compensation agreement, even if it's not signed by the parties to the purchase and sale attached. Not binding upon any broker or party who does not sign it. Any licensee signing it warrants they have authority. This paragraph E and F. Once this compensation agreement is signed, it cannot be further modified without the express written consent of the brokers whose compensation is being set forth in here. Brokers referenced herein are express beneficiaries of the compensation agreement and shall have all remedies available at law or in equity if it is breached. So, and then there's a place for special stipulations. I have a note. These paragraphs E and F above protect brokers more than if you address compensation as a special stipulation in a contract, especially regarding a seller paying buyer's broker, because the agents and brokers are a party to this exhibit. We are express beneficiaries, but the agents and brokers are not a party to the actual purchase and sale agreement in and of itself. So if a seller is paying a buyer's broker directly, this form would be preferable over using a special stipulation or being paid from the seller's contribution to buyer's closing costs. And then there's a place for buyer and seller to sign, because this is an exhibit, so they both have to sign it, and a place for the agents to sign. And then the third document is the instructions to closing attorney. You're going to use this if there is a co-op transaction, just like you guys have been used to using for years and years. If the seller's broker is paid by the seller and the buyer's broker is being paid by the seller's broker, that's a co-op transaction, and that's when you use this. Or, and additionally, you are going to continue to use this even if you have addressed compensation as a special stipulation or in one of those other two documents. This, in essence, summarizes the brokers, the listing broker and the buyer's broker compensation and who's paying what. Additionally, you also need to use this if the brokers are giving their parties any sort of commission rebate, or if there are any referral fees being paid to a third party. So again, you guys are used to looking at this. This has been revised in July. You fill in the property address, the buyer seller, the date the offer was made. And then this is how much the seller is paying the seller's broker. This is how much the seller's broker is paying the buyer's broker. Again, what we call a co-op transaction. If that is the case, then this amount is going to be larger than that amount. Now, these next two sections, this is how much the seller is paying the buyer's broker directly. And that's going to be either from a special stipulation or one of those other documents signed. And this is how much a buyer is paying a buyer's broker directly if the buyer obligated themselves to pay a certain amount to their broker and it is not being offset by the seller side. I'm going to show you how these work in just a minute. Yes, copies of this presentation, I've put them in the chat numerous times. I'm going to put it one more time. Here are the handouts that have not only the PDF of this presentation, but all of these documents with all of my underlines. So I've just put it in the chat. It's a PDF. It is enormous, but you can go ahead and download it to your computer. All right. And then the second page of the instructions to closing attorney are for fees and rebates. This is any amount the seller's broker is paying, rebating back to any of the parties, or any referral fees being paid. And this is how much the buyer's broker. So page 1 is how much coming in to the seller's broker, how much is coming into the buyer's broker. Page 2 is how much is going out from the seller's broker and how much is going out to the buyer's broker. Sarah, I am recording it, but I am not sure when it's going to be available. If it is, it will be on my YouTube channel, Real Estate Made Crystal Clear. And then everybody signs this. The agents sign this. Again, there is a place for a seller signature. However, again, the instructions to closing attorney, but the seller only signs if the seller is paying the buyer's broker directly, which would most likely already be agreed upon in writing in the broker compensation exhibit or in a special stipulation. Here are the special stipulations. Talk about these and then we'll get to the scenarios. These have been in existence since January, since 1/1/24. The verbiage was modified a bit in July 1st, 2024. Again, they are exactly the same, except special stipulation from GAR 619 references the VA. Again, check with your lender regarding current VA rules. This is already changed in June. And here's the special stipulation. More than likely, you're going to use if the buyer requests the seller to pay the buyer's broker compensation directly. Buyer hereby requests and seller hereby agrees to pay the buyer's broker at closing the following compensation for professional services: flat fee, percent of the sale price, other. This last sentence is extremely important. You guys, do not write your own special stipulation. Do not write your own special stipulation. Do not write your own special stipulation. Use this one provided for by GAR because of this last sentence to keep you from violating the license law, the unfair trade practice. So this is why you need to use this one. You must include this last sentence that says nothing herein shall be interpreted as a request to alter, modify, or change the commission. It's probably going to be changed to compensation to be received by the seller's broker, if any, that the seller may have agreed to pay the seller's broker in any separate written agreement. Do you need to send the brokerage agreements to the closing attorney's office? No. That's why you're going to use the instructions to closing attorney. If you have the closing instructions to closing attorney, This has already been agreed to. This is a summary of this, but your buyer and seller have already agreed to this. And the brokers have already agreed to this. So your closing attorney would use this. If for whatever reason you don't use these instructions to closing attorney, then yes, somehow you need to get to the closing attorney. They need some written agreement of who's paying what commission. And then the last thing is a buyer's broker. Remember, we said a buyer's broker can also get paid from a seller's monetary contribution to the buyer's closing costs. Okay, Dana, why are you saying that? Well, it's in the GAR contract. You guys, this is all with respect to contract provisions in the Georgia Association of Realtors contract. If you are a party, if you sign or your buyers and sellers are parties to other contracts, not the GAR contracts, these things are not law. These are contract provisions. You need to read your other contracts. So in paragraph A3, the seller agrees to pay X amount of dollars towards the buyer's closing costs. In the corresponding paragraph B3, it says, at closing, seller shall make the reference seller's monetary contribution, which the buyer may use to pay any cost or expense of the buyer related to this transaction, including, without limitation, any compensation obligations of the buyer, as long as it's allowed by the lender. All right. So let's take a look at this. What of all this stuff? So those are the forms.
Can I ask a quick question?
Okay.
Please? The last form that you showed, would that supersede the previous forms?
No,
Okay,
no. This is the instructions to closing attorney are just that, instructions to closing attorney.
okay, no,
This
not,
info-
not that, okay, yeah, this, the.
This is the
compensation
instructions to closing attorney.
Okay, all right, and the
These are the
last one
instructions
you
to
showed
closing
us
attorney. This
Okay.
is just a summary of how much the seller's paying their own broker, how much the seller's broker is paying the buyer's broker, how much the seller's paying the buyer's broker, how much the buyer's paying the buyer's broker. All of these have already been agreed to somewhere else.
Okay,
Now, I guess you could use this, but no, this does not supersede something that has already been. This is intended to help the
so the
closing
last
attorney know
document, the
what
very
to-
last document you just showed, it does not supersede all of these.
This is the instructions. All of this
Okay.
is instructions to closing attorney.
Okay, got it.
All right. It's not an amendment. It's not an amendment to any agreement. It doesn't change anything. It's not an amendment. It's not an exhibit. It's a separate agreement. Okay, let's move on. So we've talked about how listing agents get paid, how buyer's agents get paid. We've talked about where that is negotiated and agreed to by our public buyers and our public sellers, what they agree to. And we've talked about the forms available to you in the GAR contract package. So now, oh my gosh, it's so confusing. How do you know what to use where? Well, in summary, the seller's broker's compensation is established in the seller brokerage or customer agreement. Buyer's broker compensation is established in the buyer's brokerage or customer agreement and includes a maximum amount allowed to be received per the terms of the NAR settlement. So the biggest issue, so that's how much. The biggest issue is who is paying and how much and what do we have signed to confirm all of this. So how much is coming from the buyer? How much is coming from the seller? How much is coming from the seller's broker, or any combination of these three? This is just a reiteration of what I have already addressed. How does this work? All right. Now we've got some examples that hopefully will start to clear all of this stuff up. So how does this work in practice? Well, we have to start, especially in light of the NAR Settlement Agreement. This is not Contracts 101. This is how to fill these out in light of the terms of the NAR Preliminary Agreement. That's what these examples are in relation to. Amounts for moving forward are for illustration purposes only. There are no commissions set by law. They are negotiable, but a broker or an agent is not required to negotiate them. And this is just so you guys can see how this works. So let's start with the buyer. The buyer agrees to pay the buyer's broker 3 apples for their services. Even though I have the amounts are for illustration, I really want to talk about apples rather than percent of sale price or flat fee dollars. So we're talking about apples here, but take what you will. Buyer agrees to pay buyer's broker 3 apples for their services. Buyer agrees that the buyer's broker may receive a maximum of 10 apples. So they've agreed to pay 3, but they've agreed that you can receive up to a maximum of 10, which would be up to 7 additional apples paid by someone other than them. The buyer agrees that any number of apples paid to the buyer's broker would be subtracted from their obligation to pay the broker 3 apples. So that's what's going on. This is the buyer brokerage agreement. This is how you would fill this out to match that example. Buyer agrees to pay the buyer's broker 3 at closing of a contract, 3 apples. Buyer approves of you, their broker, getting compensation from the seller's side, either from the seller or the seller's broker. They approve that you, their agent, I'm going to say agent, but it's really broker, can get a maximum from the seller's side of 10 apples. And they approve that whatever you get as their agent from the seller's side reduces how much they owe you dollar for dollar. All right. This is how you fill out this form based on that scenario. You're going to put 10 apples here. This is going to typically be a larger amount than this to account for a bonus or something along those lines. So now here's the scenario. Okay, the buyer's broker is now, so we've met with the buyer. We've talked about compensation. That's what the buyer has signed. Now the buyer's ready to, now you're ready to go show them properties. You have a signed agreement with your buyer. Based on what the buyer agreed to pay the buyer's broker at closing, the buyer now has a choice of what houses to see. Based on any buyer's broker's compensation coming from the seller's side, various forms will be used. I'm going to go through 6 scenarios. Note, remember to have the buyer's lender verify the buyer has the additional cash on hand to meet their financial obligation to your broker that they agreed to. Most lenders are not able to finance this into a buyer's loan, but check with the lender as new programs develop. Any apples means up to, Sharon, it just means you can get additional apples from the seller's side. You have to identify a maximum amount of apples your broker can get at closing. The buyer has obligated themselves to pay you 3 apples, but you can get more. Let's say the seller is offering a bonus of 2 apples. So let me just show you an example. But yes, that typically accounts for a bonus. Key questions, you buyer's agents. These are key questions you need to ask every buyer prior to showing each and every property. You need to ask yourself, do you know if the seller's broker is offering to share part of the compensation they receive from the seller as a co-op fee? Do you know if the seller is offering to compensate the buyer's broker directly? Do you know if the seller is offering any financial concessions to the buyer directly? Do you know how much any of these are? How do you know? Do you know this information via email, text, flyer, or signed form? And does the buyer want to see this property based on this information? These are key questions you need to know as a buyer's agent and discuss with your buyer prior to showing each and every property. All right, there's a question about how much to put in those amounts in your buyer brokerage agreement, buyer agreements. Maximum, you need to get with your broker on that information. I'm not discussing any particular amounts. These are just examples so you see how these forms work. Okay, scenario number one, house number one. Seller's broker will co-op 3 apples. Buyer's broker learns from the seller's broker that the seller's broker will compensate the buyer's broker in a co-op arrangement 3 apples. So again, for all of these scenarios, the buyer said they're obligated to pay you 3 apples at closing. You can receive a maximum of 10 apples from the seller's side, and any amount you get from the seller's side gets subtracted from the 3 apples they owe you. That's the buyer situation for all of these scenarios. What's changing is what you know from the seller side. So in house number one, we know there's a co-op of 3 apples. So the buyer's broker says to the buyer, at closing, you agreed to pay my broker 3 apples. For house number one, the seller's broker will pay my broker 3 apples. So at closing, you will have to pay my broker 0 apples. You've obligated yourself to pay 3. I have found out that the seller's broker, the listing broker, is paying me 3. You agreed that what I'm getting from their side is subtracted from you. So 3 minus 3 equals 0. Do you want to see this house? Buyer says yes. Buyer's agent emailed the seller's agent asking about availability. The seller's agent emailed back, it's available and there's a co-op compensation of 3 apples. The buyer wants to see the house. Buyer's agent fills out the pre-showing compensation agreement and emails this to the listing agent at the same time that a showing appointment is scheduled. Listing agent signs this form immediately and emails it back. So this is how this form is filled out. This is property number 123 Lucky Street. Compensation being offered to the buyer's broker is 3 apples, and it is being paid by the seller's broker out of the compensation they're receiving from the seller. Buyer's broker signs it, seller's broker signed it. In scenario number 1, the seller does not sign this form because the buyer's broker's sole compensation is only coming from the seller's broker. Now, the buyer, you show the buyer the house, and lo and behold, they want to write an offer. They write an offer, seller accepts, you go binding on 8-2. The buyer and seller's agent now also complete and sign instructions to closing attorney, because the closing attorney, this form, this is just how much the buyer's broker is being paid. The closing attorney at this point has no clue how to put on the closing statement how much to pay the seller and how much the seller is paying the seller's broker. So you're going to sign, you also need to fill out instructions to closing attorney, because the closing attorney needs to know how much the seller is paying their broker, and your closing attorneys are familiar with this form. So this, for house number 1, this is how you fill out the closing attorney instructions. 123 Lucky Street. The seller is paying the seller's broker 6 apples. You as the buyer's agent have no clue until this point. The seller is the only one at this point in this scenario that knows that information. So the seller is paying the seller's broker a total of 6 apples. The seller's broker is, of the 6 apples the seller's broker is getting, the seller's broker is sharing with the buyer's broker 3 of those apples. 6 minus 3 is 3. So at the end of the day, the seller's broker gets 3 apples and the buyer's broker gets 3 apples. The agents are the ones that sign it. Seller doesn't sign because the seller is not paying the buyer's broker directly. Okay, that's what you guys have done for years and years and years. House number 2. Seller's broker will co-op 2.5 apples. Again, the buyer scenario is the same. In house number 2, the buyer's broker learns from the seller's broker that the seller's broker will compensate the buyer's broker in a co-op arrangement 2.5 apples. Buyer's broker, now you're talking to the buyer. At closing, you agreed to pay my broker 3 apples for house number 2. Seller's broker will pay my broker 2.5 apples. So at closing, you will have to pay my broker half an apple. Do you want to see this house? The buyer says yes. Buyer's agent emailed the seller's agent asking about availability. They said it's available and the co-op compensation is 2.5 apples. Buyer wants to see the house. Now, buyer's agent, you are filling out the pre-showing compensation agreement. You send that to the listing agent at the same time you schedule an appointment. Listing agent immediately signs it and emails it back to you. This is how you fill out this pre-showing compensation agreement in this scenario. Property address 456 Fortune Lane. Compensation being offered to buyer's broker. 2.5 apples. And it is being paid from the seller's broker. Not the seller, but the seller's broker. So again, only the agent signed because the seller is not paying the buyer's broker directly. Buyer writes an offer and seller accepts. Binding agreement date is 8/2. Now you also need to complete the instructions to closing attorney because the closing attorney needs to know how much the seller is paying the seller's broker, and the buyer still has to pay the buyer's broker 0.5%. So here's how you fill out the instructions to closing attorney in this situation. The seller is paying the seller's broker a total of 6 apples. At this point, only the seller's broker knows that. The buyer's agent, you don't know that. So the seller is paying the seller's broker a total of 6 apples. Of those 6 apples, the seller's broker is sharing 2.5 of those with the buyer's broker. The buyer's broker, however, is due a total of 3 apples. They're getting 2.5 from the seller's broker, and the additional 0.5 apple they are getting directly from the buyer. So in this scenario, that is how you fill out the instructions to closing attorney. House number 3. Okay, hang on. Let me look at your questions for a second before I go to house number 3. DOJ has concerns about agents steering away from houses that offer less than 3 apples. Now I anticipate buyers asking to know which properties compensate X apples. Buyers self-steer. How do you suggest protect ourselves being accused of steering? Again, very interesting perspective, Peggy. And in this situation, this is why I am presenting this scenario in this manner, and especially those questions. You need to do your best as a buyer's agent to find out any compensation you're getting from the seller's side to offset your buyer's obligation. But you are asking the buyer, do you want to see this property or not? So you might want to come up with some documentation of the buyer saying, yes, I want to see it, or no, I don't want to see it, rather than just verbal. Next question. Can we negotiate 0.5 an apple via purchase and sale? Great question. Stay tuned for another scenario. If buyer signs 3 apple buyer brokerage agreement and seller only ends up 2.5, but decide, okay, good question. That's my next scenario. Clear for sellers who offer and those who do not. What about sellers who want to see the offer before they decide on compensation? Did any form cover open-ended compensation? You cannot have an open-ended offer of compensation, Tashara. That is prohibited from the terms of the agreement. But the seller would make a counter. If you get multiple offers, you listing agents, before you agree to anything, you are just going to make a counter offer. Remember, any of this stuff can be changed via amendment or counter offers. Yes,
Dana, I'm sorry, I meant open-ended from the seller. I know we can't, but if the seller doesn't want to say what his compensation is until after they see the offer, they can't.
No, you would amend it. You need to put in a firm dollar amount that the seller agrees to pay the buyer side, and then you can amend it with any particular offer. So hang on, this next thing we'll get into that. Buyer is making the final into the abyss. Yes, Mike, you are correct. Okay, let's look at, I'm running out of time. So let's cover these next examples. In the next house number 3, the seller's broker, same scenario as the first one. There's a co-op of 2 apples. So house number 3, buyer's broker learns from the seller's broker that the seller's broker will compensate buyer's broker in a co-op arrangement of 2.5 apples. Yes, this information, McKay, is agreed to in advance in the listing agreement negotiated between the seller and the seller's broker. The buyer's broker says to the buyer, at closing, you agreed to pay my broker 3 apples. For house number 3, the seller's broker will pay my broker 2.5 apples. So at closing, you will have to pay my broker half an apple. Do you want to see this house? And I think Peggy brings up a good point. These are my scenarios. You need to get with your brokers, or as an independent contractor, you probably need to come up with some form where you identify a property and you have a buyer sign, yes, I chose to see this property. No, I chose to not see that property. I think that would probably be a good practice. Okay. Anyway, buyer says yes, they want to see it, knowing at closing, if they buy this house, they are going to have to come out of pocket an additional half apple to pay your broker commission. Buyer's agent emailed the seller's agent asking about availability. They said, yep, co-op of 2.5 apples. Buyer wants to see the house. Fill out the pre-showing compensation agreement, email it back. They sign it, you get it back. Same as we just looked at. This house number 3 is 789 Wisdom Way. Co-op being offered to the buyer's broker is 2.5 apples coming from the seller's broker out of the money they're being paid by the seller. Now, buyer writes an offer, seller accepts, you go binding. Now, the buyer's broker agrees that at closing, the buyer's broker, for whatever reason, throughout the course of negotiations, or as one of the questions was, they were being generous, the buyer's broker has changed their mind and said, the buyer's brokerage agreement said the buyer has obligated themselves to pay 3 apples. However, we are now binding, and the buyer's broker has decided they will accept the compensation from the seller's broker of 2.5 apples as total compensation and not require the buyer to pay the additional half apple that the buyer agreed to pay in the buyer's brokerage agreement. Buyer and buyer's agent, therefore, amend the buyer brokerage agreement. This now has nothing to do with the seller or the listing agent. You're going to use GAR F728 amendment to brokerage agreement. This is what this looks like. This is an amendment. It's an amendment to the exclusive buyer brokerage agreement, and this is what you're going to write. You are going to identify a specific property, because this could fall through and you could find another property where there's a bonus or something being paid. So anyway, this is how you're gonna amend the buyer brokerage agreement. For the closing of 789 Wisdom Way, per paragraph 4 of the buyer brokerage agreement, at closing, buyer's broker will accept 2.5 apples from the seller's broker, ABC Realty, as total compensation, and buyer, that should be shall owe 0 additional apples at closing. Now, what do you do for the closing instructions? To the attorney. Seller is paying their broker 6 apples. Their broker is sharing with you, the buyer's broker, 2.5 apples. No additional compensation coming from the buyer or the seller. All right. House number 4. Seller's broker will co-op 2.5 apples, and the seller has agreed to pay half an apple. That's the setup, or that's how we're going to write all this stuff out. House number 4. Buyer's broker learns from the seller's broker that the seller will compensate 2.5 apples. They say, at closing, you owe my broker 3 apples. I'm going to get 2.5 apples. So at closing, you'll have to pay my broker half an apple. Do you want to see the house? Buyer says yes. Same thing, you get it back. You're going to fill out the pre-showing a compensation agreement and email it to the listing agent. Now, the listing agent never signs it. You, as the buyer's broker, don't get anything in writing confirming that there's any co-op fee. You go show the house. They write an offer. You need to confirm that the seller's broker will pay your broker the 2.5 apples, and the buyer wants to ask the seller to pay the additional half an apple. Now you're going to use that other form, broker compensation agreement exhibit. So this is how you fill that out. There is nothing signed. The buyer's agent initiated the pre-showing, but the seller's agent never signed it. So you have nothing in writing. So now you're going to use this as an exhibit to the contract. Blah, 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 name of the buyer or the seller. This is how you fill this out. Compensation being offered to the buyer's broker. 2.5 apples coming from the seller's broker, ABC Realty, and half an apple coming from the seller. This is how much is going to the buyer's broker. Again, this bottom form, as a buyer's agent, you might not know how to fill this out. This bottom section will be eliminated in January. Because if you don't know how to fill it out, you're going to have to get a counteroffer. And now well, this is an exhibit, so everybody signs it. Now, how do you complete the instructions to closing attorney? This is house number 4, 10 Blessing Boulevard. The seller is paying their own broker 6 apples. The seller's broker, of the 6 apples the seller's broker is getting, they're sharing 2.5 apples with the buyer's broker, and the seller in this exhibit agreed to pay directly the buyer's broker half an apple. That's how you fill out the instructions to closing attorney in that scenario. Now, because the seller is actually paying the buyer's broker directly, the seller in this scenario also has to sign the instructions to closing attorney. One more scenario. Oh, same scenario. If the seller did not agree to pay the half apple on that exhibit, here's another way to do it. In the purchase and sale agreement, you're going to add that special stipulation. Buyer hereby requests and seller hereby agrees to pay buyer's broker at closing half an apple. Nothing herein shall be interpreted as a request, da, 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 da. So this is another way that the buyer can request and the seller can agree. You can either use that exhibit or you can use this special stipulation. House number 5. Oh, I'm sorry. This was house number 5. Exact same scenario, but instead of using the exhibit, you use it as a special stipulation. Closing instructions to closing attorney is the same way. House number 6. This is the last example. Hang with me. I've got just a couple of concluding things. And McKay, one of the concluding things is which is better, the exhibit or the special step? Exhibit. Okay. You have no information of any compensation coming from the seller's side. You have asked, you've requested. They did not have that Google Share document spreadsheet like Matthew Share so informatively shared with us. You have no clue. You have no communication from the seller side. Buyer's broker cannot get any information from the seller's broker regarding any compensation, either as a co-op or directly from the seller. Buyer's broker says to buyer, at closing, you agreed to pay my broker 3 apples. I cannot get any information if they will pay my broker any apples whatsoever. So at closing, if you buy this house, you will have to pay my broker 3 apples. Do you want to see this house? Buyer says, can we ask them to pay you? You say, of course we can, but they still may say they won't. Do you want to see this house? Buyer says, yep, want to see it. Buyer writes an offer and wants to ask the seller's broker to pay the buyer's broker the total of 3 apples that the buyer is obligated to pay. Therefore, the buyer will include the buyer compensation agreement in the offer. Buyer will initially ask the seller's broker to compensate the buyer's broker 3 apples. So one of the things about this exhibit, if the buyer is asking the seller's broker to pay the buyer's broker, you're going to use this exhibit. The special stipulation is if the buyer is asking the seller directly to pay part of the buyer's broker. So this is how you fill this out. This is again the exhibit. Compensation of buyer's broker, 3 apples. 3 apples from the seller's broker. You have no clue if they're going to agree to this or not. But as the buyer's agent, the buyer has said, I want to ask their agent to co-op with you. This is 12 Happy Highway. That's how you fill this out. The seller can make a counter offer for any of the terms, including the compensation of the buyer's broker. The buyer will have to proceed according to what they want to do. They can accept the seller's, so I'm getting tongue-tied here, I'm sorry. The seller makes a counter offer, and the buyer, based on what comes across in the seller's counteroffer, decides to accept it, makes their own counteroffer, rejects it, and goes and finds another property. Any number of scenarios play out. There are a ton of additional scenarios. We cannot cover them all. Check with your broker on policies and stay informed. Now, just a couple of concluding notes on these compensation forms. Ideally, you guys would get a pre-showing compensation agreement signed by both buyers and sellers agents prior to showing. This way, the buyer has reliable information that impacts their potential financial obligation to the buyer's broker at closing, should they buy the property. Note, the instructions to closing attorney form signed by both agents can also work in this manner or work as a summary. Next best option. Use the broker compensation agreement exhibit for a co-op compensation and or seller direct compensation of buyer's broker. This is preferable over a special stipulation, McKay, because this agreement cannot be changed via an amendment solely signed between the buyer and the seller. Remember, I pointed out those special paragraphs E and F. The exhibit stands alone, even though it's an exhibit. It can't be changed by the parties affecting broker compensation. Next best option, the third best option, would be to use the GAR special stipulation for the buyer asking the seller to pay the buyer's broker directly. Potential issue is that, again, this special stipulation can be amended by the buyer and seller only. It affects your compensation without you having any say. Best practice, use the instructions to closing attorney in every contract to summarize the compensation arrangements for the closing attorney. Considerations with respect. It may require additional communication between you guys prior to showing to determine the buyer broker's compensation. It's critical to convey this information to a buyer so that the buyer has full knowledge of their financial obligation to a buyer's broker at closing based on what they agreed to and signed in the buyer's agreement. Give the buyer the option of seeing or not seeing a property based on this information and its financial impact on the buyer. Contracts and brokerage agreements and compensation agreements may be amended with all respective parties agreeing to terms. Communicate co-op compensation where possible. So best practices for seller's agent. If you get a showing time, immediately have your pre-showing compensation agreement already filled out or instructions to closing attorney, and you get a showing time notification immediately, not through showing time, but separately email that to the buyer's agent. Have co-op compensation in, again, we've already talked about this, flyers, social media, so forth and so on. Be aware of any MLS provisions, FMLS being independent, GAMLS and others being NAR members, regarding communication of compensation and how it relates to your broker's policies. Best practices for buyer's agents. Make sure your lender pre-qualifies your buyer with that cash. Do an estimate cash to close, including any of their compensation obligations, and do what you can to determine any compensation coming from the seller's side. Myths and busting them. Brokers must negotiate all compensation with buyer and seller. The myth buster, compensation is negotiable and not set by Georgia law. However, a broker and agent is not obligated to negotiate the fees they charge. Myth, sellers, brokers may no longer offer co-op fee. Nope, sellers and brokers may absolutely offer co-op compensation to a buyer's broker. It just may not be presented in an NAR member MLS. Myth, broker's compensation may not be addressed in a purchase and sale agreement. Buster, in Georgia, in a purchase and sale agreement, buyer and seller may negotiate any number of financial concessions, including asking the seller to pay the buyer's broker's compensation. You guys, bottom line, this is a great opportunity for Georgia agents to educate our consumers, explain what they do, explain how the process works, explain the benefits of agency representation, and how they protect buyers and sellers and their specific interests with respect to a contract. And as was mentioned earlier, Cheryl, a PowerPoint I have done in the handout that I've released in the chat. Agents are now on the same page. So again, are agents not going to adhere to it? I don't know, but this is an opportunity for agents to all be on the same page in terms of consulting with a buyer prior to simply opening up a door. The GAR contracts have included many of these compensation negotiations provisions for years. And again, as I've cautioned you, be careful of the national conversations, because our laws in Georgia and our contracts are way ahead of many other states. And also be aware there is a lot of confusion about the settlement agreement and how it impacts the public. There is a lot of GAR resources you can go to. NAR resources, go to their website and they've got frequently asked questions, so forth and so on. And other resources, your broker, your sales meetings, your broker's publications, manuals, guides, your broker's online email communication, your local association of realtors, other CE classes, and your preferred closing attorney. Woo! We made it, you guys. Thank you so much. Again, confirm all contract questions with your broker. That is the website of our school for additional CE classes. I do, as I mentioned, have a YouTube channel, Real Estate Made Crystal Clear, where I discuss contracts in depth. I've got videos on all of these compensation agreements, as well as license laws, ethics, so forth and so on. And I encourage everyone to please continue to be a blessing to with the license that you have by helping others with their real estate needs. I appreciate your time. It is a lot. We will all get through this. You are free to go. I see a bunch of people are putting in, I need your name, email address, and license number prior to going. I've just put the document again.
Do you have the survey? Didn't you say something about doing a survey?
Yeah, it was launched as a poll. I can't relaunch it. So if you didn't get it, that's fine. I will post the handout. If you go to this website, realestateacademyofamerica.com, I will post the handout there too. We've got a separate tab for course handouts and videos. So I will post it there. Yes.
I have a kind of, and it may just be me in my head on this, but the compensation to brokers in your listing agreement, you've got the option that says compensation to seller's broker. Seller agrees to pay seller's broker the following compensation, and then optional, seller hereby approves the following compensation, if any, to be paid by the buyer's to the buyer's broker. Now, we as the buyer's broker may not know what they have chosen. And if we're sending that exhibit to the broker and the broker's not authorized to pay it as the broker, how does that affect how we need to present it?
You can do it a couple ways. And that's why GAR is taking that out of that exhibit, because it's either going to force a counter offer. The seller is going to have to make a counter offer correcting that exhibit. And then the buyer agrees or doesn't agree.
Well, that's in the listing agreement though, not the exhibit. Oh. That's in the listing agreement.
So if the seller agreed that their broker can co-op,
or if the seller said no.
If the seller said no, yeah. Okay, the seller.
If the seller said no, we don't know because they've ghosted us, which they do. And we send the offer with the exhibit, not with a special stip.
Yep.
And
it's still an exhibit to the agreement. So either the seller can change their mind, or if the seller says, no, I'm not offering a co-op fee, buyer, you need to pay your broker what you agreed to pay your broker. I'm paying my broker. I have nothing to do with your broker. I'm not paying your broker anything. But as the buyer's agent in preparing the offer, the buyer asked you to ask the seller's broker for a co-op fee. So you prepare that exhibit, you send it as an offer.
Okay.
The seller is going to make a counter offer saying there is no compensation for the buyer's broker coming from the seller side.
Remove that exhibit.
It's just a
and
counter
that's-
offer like you counter anything. And the buyer says, so then at that point, the buyer's going to owe your broker at closing whatever they agreed to in the buyer brokerage agreement. The buyer says, yes, I'll accept the counter offer and buy the house. Or the buyer says, no, I'm not going to buy the house and go find another house. It's a term that gets countered like any other term in an offer or counter offer that gets countered. So it just is just like
I just want to, in my head, it was almost like a running into a brick wall that you didn't expect. But you're absolutely right. It makes sense. You just amend, or whatever.
It's just like a buyer can write an offer saying, I'm writing this offer contingent upon me selling my current home, sale or lease contingency. So I said, nope, I'm not taking it. They make a counter offer saying, I'll take your offer, but you have to go through with it. I don't care if you sell your house or not. And the buyer says, okay, I want the house. I'll just deal with it. Or I can't afford to go through with this. I'm not in a position to go through with this. If I don't sell my house, I need that protection.
So in essence, and you just threw something else out there. In essence, you could put a contingency in there. This offer is contingent upon the compensation. No?
I
can't
would
do it as
not
a
use that
contingent?
verbiage. I would
Okay.
not use that verbiage. That is not in the spirit of the terms of the NAR settlement.
Okay. Okay. Makes sense.
Use the GAR forms as they are presented right now. Again, you guys pay attention. We start teaching the 2025 GAR contract changes in December. There's going to be a lot of changes, but no, I would not use. I would not encourage. Check with your own broker, but I would not encourage the use of that word contingent or subject to. That brings in a lot of. I just wouldn't. I would use the forms as they are.
Did I understand you to say once the seller actually indicates how much they're going to pay, the total amount, it can't be changed, or it can be changed?
Oh, it can always be changed.
Okay.
You
From
guys,
the
we
seller
change
side.
everything
Okay.
as long as it's changed in writing with agreement signed by all parties.
Okay.
You guys, things change all the time. Do sale prices change? Yeah, sale prices change. Do seller concessions to buyers for repairs or money towards closing costs, do those change? Those change all the time. Does compensation change? Do brokers sometimes end up giving a rebate back to a client? Does sometimes a broker pay for a home warranty? They didn't initially agree to that. Like we addressed in one of the scenarios, buyer said buyer and buyer's agent negotiated that at closing, buyer's obligated to pay their broker 3 apples. Find a house, the buyer's broker is being compensated by the seller's broker or the seller, whomever, 2.5 apples. And then right now, the buyer's still obligated at closing for that extra half apple. Buyer and their own agent negotiate and change it. No, guess what? I'm fine with just the 2.5. My broker will accept as total compensation the 2.5 apples I'm getting from the seller side. I'm negotiating that. So you amend the buyer brokerage agreement. Sellers initially can say, I'm not paying any.
Okay, that's what I wanted to know.
Based on what some of these sellers are hearing, the sellers can say, I'm not offering any co-op. I'm paying you. I'm not paying you more. I'm not allowing you to share any of the money I'm paying you with the buyer's broker. I'm not paying a buyer's broker directly. And
Dana,
throughout the course of events, and maybe because of timing or showings or lack of showings or offers, the seller says, maybe I need to change this compensation thing and change it. So again, the seller can amend their listing agreement too regarding co-op compensation or compensation offered to a seller, or seller can say in the seller's agreement, I'm not paying anything to a buyer's broker. And then based on the offer, it could be the offer comes in so high, but it only comes in high because the buyer needs the seller to pay their commission obligation or their compensation obligation to their broker. So they come in over list price and say, okay, seller, I'm giving you more money for the house, but I need you to pay I don't have the cash. So I need you to pay my obligation to my broker at closing, the compensation.
Yeah.
And you do that as the special stipulation. So I said, great, I'll do that because I'm getting more for the house, and it net ends up the same. So just like anything, you guys, these terms can be negotiated via amendment with agreement and written disclosure and written agreement.
Okay, thank you. Great
Okay, question about if a builder's offering a bonus. So let's say you sign a buyer brokerage agreement for the 3 apples and you don't put anything. You put maximum 3 apples, or you leave that blank. And then you go and the buyer buys a new construction, and a new construction builder is offering a bonus of 1,500 apples. Well, guess what? If you don't have in your buyer brokerage agreement, the buyer agreeing that your broker can accept that additional bonus, those additional 1,500 apples, I don't care if the new construction's offering it or not, you cannot accept it. Now, can you then go back and amend your buyer brokerage agreement to say at the closing of this new construction house, buyer allows buyer's broker to accept 1,500 apple bonus? Yes, if the buyer agrees to that. Or new construction seller is offering a 1,500 apple bonus. Well, you can go back and say, okay, they're offering a 1,500 bonus. How about you allow my broker to get 750 of those apples, and you get 750 of those apples? Well, then you amend the buyer brokerage agreement to reflect that. So that was the answer, Sandra, to that question. And I see some other people shaking their heads. It's a lot, isn't it? You guys, we all need to catch our breaths and continue. Everything will be fine if you remember to keep the best interest of the consumer with whom you are working, the consumer who has hired you, whether that be the buyer side or the seller side, in mind, as well as Realtor Code of Ethics and business ethics, and working together as a trade, regardless if you are a realtor or a non-realtor. And our job is to help a buyer buy a house and a seller sell a house, and we get compensated for the professional services we provide. But GAR has created a lot of these forms. They've created these forms to give us options. Sometimes I think it makes it too confusing, that you could do it this way. You could use this exhibit. You could use this pre-showing. You could use this. You could use that. Sometimes it has become a little bit more confusing. I think, again, these revised GAR forms and that new exhibit have just come out July 1st. The NAR preliminary settlement is not effective until August 17th. I think there is going to be a lot of trial and error and best practices and confusion that brokers are going to work with, GAR is going to work with. Things are going to change as far as how we as agents in Georgia practice using these forms. And there's going to be some things that you are going to find more comfortable and more not comfortable. There are going to be things that your buyers are going to understand more readily. Your sellers are going to understand more readily. Some things you're going to be like, this is way too confusing. Okay, well, let me find a different way to achieve the same thing. Can a non-NAR member access the Q&A via their site? Is that, Faye, are you asking about on the NAR, the GAR site? No, you have to have
No, the slides. No. At the end of your presentation, you had places
resources.
Resources. You had several of their sites.
Okay, so so let me go back and share my screen so you guys can see what Faye is talking about. And this is in the handout. It's going to do it. GAR resources, you do need an NRDS number, which you get by being a realtor. So for the GAR resources to access these things from GAR's website, you do have to be a realtor with an NRDS number. For NAR resources, you do not need to be a realtor. You do not need to be a member of NAR. Just go to nar.realtor. And you will, and if you download the handout, these are hyperlinks, so you can link them, you can get to them right from here. but you can access any of this information from NAR's website without having to put in any type of NRDS number. And if you just go to Google and put in a question, you know, NAR settlement, typically the first documents that show up are documents posted on NAR's website.
How about the existing listings that we have? Do we have to go back and, okay, we can move forward on that?
It's just moving forward. Any documents initiated from, depending on what your broker's policy is, but with respect to the NAR settlement agreement, it is as of August 14th moving forward. You don't need to go back and re-sign any new, you don't have to re-sign anything if it's already signed. It's just documents being initiated and signed moving forward.
And my last thought, I think I understood this correctly. I'm not sure that a seller can go back and adjust the compensation that they want to give the buyer's agent if they agree to something prior to. So they
Yeah,
can
of course,
go back and
anything
change
can
it.
be
Okay.
amended. You can
Well,
amend
this is
anything.
okay. Well, this is my, yeah, I heard that piece. This is
Okay.
this is where I'm going. If a seller does that for a buyer's agent and that affects the oh, that's the compensation. I'm thinking about earnest money, so that doesn't come into play. I don't think my question is going to stand up.
Okay.
Okay.
There is a question nobody raised, or I just talked too much and ran out of time.
Okay.
Having a buyer sign an agreement that discloses compensation prior to seeing a house. If you are an agent holding an open house, or
Oh.
you get a sign call, that buyer does not, the NAR settlement states that buyer does not have to sign an agreement. Why? Because compensation is coming from the seller side that your broker already has an agreement with. If you're holding an open house, you're holding it open on behalf of a seller, and any buyer, again, not working with an agent that wants to write an offer on that house. This is taking, we're not talking about dual agency or anything like that. We're just talking about compensation. The seller, remember in the listing agreement, already agreed to pay the seller's broker. And they agreed to pay, that's why GAR has verbiage. GAR's very smart. They've also agreed to pay the buyer's broker. So let me show you quickly. I have this up. Let me show you, where is it? Let me show you what I'm talking about and why this has it. Because this is for, let me share my screen. This is for sign calls and open houses. Again, I'm taking the dual agency discussion out of it. For dual agency, let's just say you're working with the buyer as a customer. So see how it has how much the seller's paying the seller's broker. This is the listing agreement. How much the seller's broker agrees that the sellers, that their own broker can share with a buyer's broker, or how much they're agreeing to pay a buyer's broker. But see this verbiage right here? These two sentences right here, this one sentence. For all purposes herein, the term buyer's broker shall mean the broker, including the broker representing the seller, so including the listing agent, if they are also working with or representing the buyer as a customer or client. In other words, seller says, I agree at closing to pay you 6 apples. I agree, of those 6 apples, you can share 3 of those apples with the broker working with the buyer. Now, you're the only broker involved. Your seller side of the broker is going to get 6. And of those 6, you're sharing 3 with the buyer side. Well, you have both sides, but you're operating wearing 2 hats. So without anything else, that broker is going to get a total of 6 apples for working both sides. If the seller says, if there's no other brokers involved, if there's no other agents involved, I don't want to pay that much, you would spell that out here under separate conditions. If seller's offer of compensation is conditional, that would be, for example, if no other agent is involved in the transaction. At closing, seller agrees to pay seller's broker a total of 5 apples, 4 apples, whatever. So that would be spelled out there. So that is to account for, so what that means as far as what we're talking about, as far as the term of the NAR settlement about getting a buyer to sign something, you don't have to because you're being paid by the seller who's already signed something. All right. Rentals, none of this, Lorena, applies to rentals. This has strictly to do with residential sales. Can the listing agent ask to see the buyer's brokerage agreement? Why would the listing agent want to see the buyer? You can request it, but you don't necessarily have to show it. There is part in the GAR purchase and sale agreement that does state that the brokerage agreements are incorporated in the contraction, but into the contract. But that really has to do if there is a default and how much a party would owe a broker should there be a default. But you can ask, but you don't have to comply. I don't understand why it would typically be the other way around. The buyer's broker would want to see the listing broker's agreement, but that's why GAR has all of these forms and these special stipulations. You address compensation via pre-showing compensation agreement, exhibit broker compensation exhibit, pre-showing agreement, exhibit, or special stipulation. And then the other thing is, again, through the closing costs. All right, you guys, I think we are done for the day. This was a lot. I appreciate you guys all being the first class that I have taught. I really hope I met my goal. Half of everybody is gone, but I really hope that I met my goal, that the 3.5 hours now has gone by very quickly. But I hope, as confusing as this is, I hope at least I chipped away at a little bit of the confusion and at least gave you some scenarios to go think about on how to use these GAR forms that GAR has so graciously provided for us to help us as agents in Georgia. I say us, I don't deal with the public anymore. I'm what they call a non-competing broker. So I just broker, teach, and manage, but to help agents in Georgia successfully navigate and comply with the terms of the settlement. So I thank you guys so very much. And I will be available for questions, not immediately now. I do have another appointment, but email me. My email is on the beginning of the presentation. And let me look at one more. Yeah, role playing in the office would be great. Can you put pre-showing agreement on an MLS listing as a listing agent? Great question, Sandra. FMLS's rules say, yes, you can include any documentation that addresses compensation on FMLS. Georgia MLS, Navica, any other NAR member MLS, absolutely not. You cannot show any pre-showing agreement, instructions to closing attorney. You cannot attach it as a listing document. An NAR member MLS, Georgia MLS, Navica, any of the other NAR member MLSs, no, nothing about compensation can be on there at all in any form, fashion whatsoever. Can't be in a field, can't be in remarks, can't be hidden code, can't be attached as a document. Nope, nope, nope. That is one of the hugest parts of the settlement agreement. And that is, and again, it's weird for us, but in other parts of the country, the MLSs, they operated a little bit differently. And so no, the answer is no.
So FMLS has an advantage. This is has a great advantage. We can't say compensation, can't use that word compensation either.
Yeah, you can use compensation. I'm not gonna give an opinion as to advantage or disadvantage. They have different operating models. There is a lot of different information being shared in Metro Atlanta regarding realtors and the various MLSs, and that would be a discussion outside of this class with your broker. Various brokers are coming up with policies, procedures, guidelines, suggestions. That's between the MLSs and the brokers. Yes, on FMLS, it is okay to attach these documents. The pre-showing compensation agreement, instructions to closing attorney, exhibit, any document regarding compensation is allowed on FMLS as of this date. Stay tuned. Log on to FMLS and read the information they share on that home screen. That's where they will update members regarding FMLS's policies, procedures, and guidelines.
Okay.
All right, everybody. Thank you guys so much. And as I mentioned, go out and continue to be a blessing to others with the real estate license you have earned. And I appreciate your time, and I thank you so much. Bye.